them were unknown to EDC at the time that it contracted with West Dawn. During the course of Mr. Cockrell's argument, he made a submission that the allegations of state capture were unknown to EDC. I find that a remarkable submission, and it's just not credible with respect. And what is relevant is that at page 51 of the founding papers, there's a chapter, and it's entitled State of Capture Report and Commission of Inquiry. And the deponent then deals with it in 4 separate paragraphs. And he says in November 2051, my lady, in paragraph 86, the deponent says in November 2016, the Public Protector of South Africa released to the public through a court order report titled the State of Capture Report. The purpose of the report was to investigate alleged improper and unethical conduct and so on. And then there's a page and a quarter about this report. This deponent speaks as though he knows about it. Now, attached to the founding papers is an annex number 27, and you'll find it at page 394, and I would ask you to go to that page. There you will find an article written by Richard Poplak. I believe he is a South African who has spent a lot of time in Canada, and he writes about EDC in this article, and as I say, this is an annex to the applicant's papers, so I am at liberty to refer you to it. And the article is entitled How a Federal Agency Helps Finance Some of the World's Most Corrupt Regimes. Now, that federal agency to whom he's referring is EDC. He says at the top of the page, Export Development Canada has perfected the art of lending billions of taxpayer dollars to scandal-ridden foreign buyers, but its transparency could use some work. He continues, in May 2017, a trove of hundreds of thousands of emails was leaked to the press from an organization belonging to the Gupta family, and I'll skip a few lines.
Copy also very fine print.
It's very fine print, and it's quite difficult, my lady. I can get you a better copy in due course.
We're starting at May 2017, not like the Panama.
Yes.
Oh, that is great. Right.
And then about 4 lines down, for years journalists reported that the Guptas, along with members of Zuma's family, ran a syndicate that siphoned hundreds of millions of dollars from government institutions into offshore shells. An opposition leader devised the word Zupta to describe the union between the two clans. And then I skip a few lines. According to the emails, the brothers paid for a lavish wedding for their niece in 2013 with $8 million taken from a state-backed dairy scheme meant for impoverished farmers. It's in relation to that very scheme that part of this case is made out. Then further down in that paragraph, but long before the emails leaked, the brothers were already infamous for their outsized influence over Zuma, a process now referred to as state capture. Their niece's opulent nuptials generated headlines across the world, mostly because the Guptas managed to get permission to use a military base as a landing site for the hundreds of wedding guests, bypassing the usual immigration controls. The media attention had immediate and important legal implications. It rendered the Guptas politically exposed, a term used to describe entities with a potentially corrupting influence over government officials. Political exposure typically sets off alarm bells in banks, auditing firms, and financial institutions. It should have rendered the Guptas toxic, yet that never happened. Indeed, their money was especially welcome to two Canadian corporate headquarters, one in Montreal and the other in Ottawa. Montreal is where Bombardier is located, and Ottawa is where EDC is located. In a lengthy email thread strung out over the course of 2014, it was revealed that Bombardier had negotiated the sale of a luxury jet to a subsidiary of the Gupta umbrella firm Oak Bay Investments. The new aircraft came outfitted with, I'll skip a few words, at a price tag of $52 million. Been surprising was this: $41 million of the jet's financing was provided directly to the Guptas by Export Development Canada, a Crown corporation owned by, well, you. EDC's mandate is simple and ostensibly unobjectionable. Since its establishment in 1944, it has served as an export credit agency that uses federal money to facilitate trade deals abroad deemed in the national interest. And
You read from 390?
from 395, my lady. Then, just short of halfway down that paragraph, the top paragraph, the jet deal, however, serves as an example of how EDC can inhabit a grey zone between facilitating Canadian businesses and financing corruption. Before the Guptas began negotiating with EDC, they'd been turned down for loans from two big multinational lenders. EDC was far more eager to help the Guptas, but it still planned on sending one or two investigators to South Africa prior to locking in the loan. Whether or not it dispatched a team remains unclear, but it seems impossible that any investigators would have missed signs of the Guptas' political exposure, either on the ground in Johannesburg or on Google in Ottawa. According to its published list of regulations, EDC must assess profiles of companies or individuals who present risks of reasons including being named on official lists such as terrorism, corruption, or sanctions lists, being identified as politically exposed, being investigated, charged, or convinced of illegal activities, being subject to allegations of wrongdoing, or being subject to adverse media. In late 2014, the Guptas qualified on at least 3 counts. EDC has never taken an official position regarding the Gupta revelations in the leaks, other than to say that all transactions undergo a rigorous vetting process. But the agency's silence and inaction were not shared by the global banking sector. As of this writing, South Africa's big 4 banks have dumped the Guptas as clients, Standard Chartered stopped dealing with them in Dubai, SABC shut down accounts held by front companies associated with the brothers. India's Bank of Baroda is attempting to, I'm not sure what the word is, something to close down their accounts, while the Johannesburg Stock Exchange successfully pushed Oak Bay to delist itself. But the Guptas are not EDC's only controversial clients. The agency's client list is studded with some of the most scandal-ridden multinationals on the planet, including Kinross Gold. Its West African mining corporations were, as of 2016, under investigation by the United States Securities and Exchange Commission for bribery and corruption. Despite being backstopped by the government, EDC has consistently rebuffed any request to reveal details of its lending practices. And while the Gupta deal suggests there is almost no entity that EDC won't bank, its activities are protected by disclosure protocols that are entirely opaque. EDC is effectively a black box, with the result that few in Canada, including the minister presiding over it, seem to know how the full details about what the agency does, who it finances and why. With EDC's mandate for review up for review in 2018, it seemed like a good time to examine the considerable reputational risks the agency often takes. Do Canadians want to be shareholders in a government agency that puts profit above accountability? And so if you carry on reading this, there's much more of the same about a reputation that is in tatters. And at the top of page 398,
You say there really is no reputational risk there.
indeed, yes. There's a reference to a discussion with Taylor. Taylor was a representative of EDC to whom Poplak spoke. Taylor remained calm throughout our conversation. Nothing ever fits into a box tidily, he said, of EDC's continued involvement with the Bombardier and the Guptas. We rely on third-party experts specific to either a sector or a place. Different countries treat different things in different ways. And when it comes to Bombardier and these accusations, you really need to look for proof. If you get to the point where there is a lot of noise but the contract was secure, well, he shrugged. I asked Taylor how, despite the steady stream of Gupta scandals reported since 2010, EDC appeared to have found everything in order. EDC has to do the work itself, he said. You have to rely on people who are unbiased, and we're unbiased. It can't just be media reports. It's not enough. As for the EDC loan to the Guptas, it turned out that the money was just as peripatetic as the aircraft itself. According to leaked emails, after EDC financed the Guptas' purchase of the Bombardier jet, the family immediately flipped the plane to an Irish shell company, that's Stone River, thereby avoiding duties and tariffs, and began leasing it to themselves in order to generate expenses that could write off against their profits. And then I just want to point out a comment at the end of the article in this publication, The Walrus. It's at page 399. It's just above the description about Richard Poplak. It says, on December 21, 2017, 2 days after this article was published online, Export Development Canada announced that it was suddenly terminating its 41 million loan to South Africa's notorious Gupta family, intended for the purchase of a luxury Bombardier jet. As Richard Poplak reports in our story, the Crown Corporation was criticized for its decision to finance the sale in 2014, given the extensive and widely known corruption charges that have been leveled at the Guptas over the years. The Gupta deal, however, remains one of many ethically dubious and controversial financial transactions EDC has yet to answer for. So, we say that this is a face-saving exercise by EDC, and that this well-publicized urgent application is too little or too late to salvage its somewhat shabby reputation. Now, the applicant's case for urgency. The founding papers are 426 pages long. They raise complex contractual issues. There are 2 long agreements with many schedules. There is reference to the Cape Town Convention. There was a lot of material for a respondent to traverse in answering this application. It was launched on the 15th of February of this year for hearing on the 6th of March, and it gave 6 court days for delivery of the answering affidavit. We submit it's simply preposterous when viewed in the context, and the context is the prior knowledge of the facts that EDC has had for months, if not years, before it came to court. The urgency must be viewed in the light of the basis for the termination of the lease. And I want to address that briefly. There are 4 stages here, my lady, and these stages are relevant to the question of urgency, and that's all I'm dealing with at this juncture. The first stage is October 2017. During October, the applicants attempted to terminate the lease agreement. That was on the 20th of October.
That was the first attempt.
And yes, the first attempt, and it was because of non-payment. It turned out that the payment, in fact, had been made before the termination. They happened on the same day, and the termination was withdrawn. Then the second stage is December 2017. There we have a termination on the 13th of December 2017, and it's in Founding Affidavit Para 15 at page 305. Sorry, FA 17 at page 305, FA 17. It's in paragraph 58 of the founding papers.
Sorry, I didn't get that. So it's
It's FA 17,
Yeah.
page 305, and the founding affidavit, para 58 at page 32. And what are the events of default that are relied upon for the 13 December cancellation? They are firstly the failure to provide documentation requested on the 18th of October 2017. So this very December termination finds its roots in something that happened actually on the 18th of October, when there was a request for information. The applicants say that the information wasn't provided. Now, I don't want to dwell upon that. I can just point out to you that it's addressed in the answering papers that information was provided on both the 27th of October and on the 15th of November. And that information you will find in annexes AA...
So one was on the 22nd and then on
the 27th of October and 15 November. On 27th October, AA 15 at page 119 is provided, and on 15 November, AA 16 at page 1357 is provided, and together they comprise 188 pages of information. Now, whether or not that's inadequate, we don't have time to address in the urgent court. But what I can tell you, my lady, is that this happened in October and in November, and you must keep that in mind when you assess an application brought on the 15th of February of the next year. So that's the first ground, this failure to provide the information, which they didn't have months ago. The second ground for the 13 December termination is the investigation by the public protector, which was viewed by the applicants as pending proceedings against West Dawn and Oak Bay. Now, my learned friend has taken you to these various clauses. I'm not going to take you to them again. We know what the contract says. There are a whole lot of breach clauses. If you don't do this, that, and the next thing. And some of them are really quite silly, and I'll address that in due course. But if you don't do many things, you can the lessor can terminate. So they relied upon the public protector's report and proceedings as being proceedings which constituted a breach. And
that was in November.
Now, of course, we know that the 2nd of November 2016 was when it was published. Then the third ground upon which they rely for the 13 December termination is that the third respondent is no longer the chairman of Oak Bay. My learned friend took you to that provision. It's a bit vague. It doesn't tell you which of the guarantors is supposed to be the chairman. But leave aside that point. The third respondent resigned on the 16th of October 2017. No, that's correct. No, that's wrong. Sorry, that's wrong. He resigned on the 8th of April 2016. Sorry, mate. And this was deemed as a breach of the warranty on the 16th of October 2017. So it's an event which happened years before. The breach is recognized in October 2017, and it sustains a cancellation in December, and it's a basis for urgency in February the next year. Then the fourth ground is the liens that were granted over assets in 2008 and 2011.
Sorry, what
Now,
was that?
2008 and 2011. Liens.
Oh, yeah, the liens.
Liens, yes. Another matter that was addressed by my learned friend. And those liens constitute an event of default in the applicant's case, and they constitute a basis for this termination. Now, interestingly, the respondents were called upon to correct that or to remedy that breach by notice dated 18 October 2017. You'll see that at FA, Annex FA5 at page 274. So they were called upon to remedy the breach in October.
That was October notice.
Yes. So that's the fourth
So
ground.
the October notice, sorry, the October notice dealt with the failure to pay as well as this breach.
Yes, there were two letters, in fact, on that date. But the significant point is that this cancellation was based on matters that were known and which were raised and addressed months before. The fifth ground on which they rely for the 13 December cancellation is the disposal of a material part of the assets. That's addressed in paragraph 51.5 at page 26 of the papers. That disposal, according to the founding papers, was announced on the 23rd of August 2017. So it's another event which was in the public domain months before, which is relied upon for the 13 December cancellation. And then the sixth ground is the material adverse change. That's addressed in paragraph 52 at page 27 of the founding papers, and there are four elements to the material adverse change. They are that the four major banks have closed their accounts for the Guptas and the Gupta-related companies. Now, as I recall it, that happened years ago, I think in 2016. The Bank of Baroda gave notice that it was shutting down its account. That happened in July of last year. I know that since then, in the previous month, they've indicated that they want to leave the country. There's been an application brought to restrain them from doing that, and judgment is still awaited in that matter. But the Gupta,
It was in July 20.
July 2017 was when they gave the first notice. There was a judgment on the 9th of October last year by Judge Makhoka, where he said you haven't given reasonable notice, and there's an application pending before the Pretoria High Court. Then the third element of the material adverse change is that that's Oak Bay Resources and Energy, delisted. And that happened in July of 2017. So that's also months before. That's the delisting of all. And then the fourth element of the material adverse change is the resignation of the auditors. Now, KPMG resigned in April 2016. Then there was a Seasway. They were the auditors until September 2017. So these again are events which were known of.
Sorry, give me that month.
September 2017 was the Seasway resignation or termination. KPMG was April 2016. So for these reasons, events that happened over the previous years or previous months, there was a termination on 13 December 2017. Then the third stage that I want to address is January 2018, where there was a further termination of the lease. And that January termination was premised upon two elements. The first was the ESCOM proceedings. Now, the ESCOM proceedings were launched on the 14th of December 2015. The attorneys in the ESCOM proceedings are the applicants' attorneys in this matter. So I assume the applicants would have known about those proceedings. And they arise from matters which are well publicized from 2015 onwards. That the acquisition of Optimum and Koenfontein mines That arose in the public domain in 2015. There was a great deal of publicity about it in 2016.
Sorry, which event was this? Sorry, Lee?
15 and in 2016.
Yeah, what is the, sorry.
Great deal of publicity
Around what?
around the Optimum
Oh, yes,
and
the
Koenfontein mines and the acquisition by the Optimum from Glencore,
Yeah.
by I forget the actual detail of it. But this was, these matters have been in the public domain for years. And in January, they are the ESCOM proceedings launched the previous month on the 14th of December are used as a basis for that termination. And then the second element is the poker proceedings, which came before the Free State High Court on the 18th of January 2018, which this morning effectively have been set aside. My learned friend Mr. Baroda will address you on that. There was a judgment granted this morning, and as far as these respondents are concerned, they're out of the picture. You can draw a line through the poker proceedings in this matter. But apart from that, the poker proceedings relate to the Estina dairy farm, which has been in the news since the wedding, 2013.
Those that you financed the wedding.
Right. Yes. That's the question. Now, what are the defaults that are alleged by the applicants in relation to these events? The first is prohibited payments. Now, those prohibited payments, they glean from the poker proceedings, but there is no evidence of those payments before this court. And we submit that that should not be permissible. My lady, I should have mentioned this to you at an earlier stage. My learned friend, Mr. Bester, is going to address you very briefly on the strikeout application, which, with your leave. Then the other default is the breach of the warranty or the representation concerning proceedings pending. The third is the seizure or appropriation or confiscation of assets. Well, in fact, in the poker proceedings, which the orders which have now been set aside were simply preservation orders and on an ex parte basis granted. So those are not allegations which are tested at all. And non-compliance with the law is a further ground. Misstatement of financial statements is a further ground, and breach of a personal guarantee, all relating to these poker proceedings. So what do they do in consequence of those breaches? They issue a further termination notice on the 25th of January of this year. That's in paragraph 84, page 50 of the papers. And in addition, following on this, they seek to make some mileage out of the state capture report. Yeah, I gave you the page 51, where they deal with the state capture report. It's not clear to me how that fits in with their cause of action, but what is plain is they knew about it and presumably have known about it for a considerable period of time. The fourth stage is February 2018, and the relevant date being the 23rd of February 2018, when a further notice is issued. And it relates to the annual financial statements of Oak Bay, which had been requested and not provided. And my learned friend addressed you on that. Now this is interesting because the request for those statements was made on the 18th of October. There was a notice of non-compliance given on the 6th of December 2017, and 30 days were given within which to comply in terms of the contract. So in other words, that a breach became a breach once the notice period expired. 6th of January 2018 is when the notice period expired. So as from 6th of January 2018, the breach had manifested itself and they could have relied upon it. That's RA 18 at page 1506. Now, this is a ground of termination that they rely upon in addition to the others in reply. And they criticize us for not dealing with it in the answering affidavit when it wasn't before the court. We submit that it is curious that on the 15th of February of 2018, the applicants should apply urgently for relief that stems from events that transpired over previous months and years.
What was the date?
15 February is when they launched this. That's when they launched this application. And as I've just demonstrated to you, it relates to events over prior months and years. Importantly, having cancelled on the 13th of December 2017, which brought about a claim at the instance of Westall, launched on the 18th of December 2017 in the English courts, challenging the termination, making it clear that there was a dispute about the termination and that these respondents were not going to roll over and accept this termination. That was abundantly clear on 18 December. So having terminated on 13 December, knowing the attitude of the respondents, them having gone to the trouble of instituting proceedings, if there had been a legitimate concern about substantial redress in due course, they would have launched their application then and there. They didn't do it because there was no real concern about the aircraft, and there remains no real concern about the aircraft. The applicants were asked in the answering affidavit, tell us when you started preparing these papers. Tell us when counsel were instructed, when the attorneys were instructed. And they say, well, they're not going to give us that information as privileged. But they don't let you, my lady, into the picture and tell you what it is they did from 13 December and why it is they did nothing about launching an application if they were so concerned about the aircraft.
Will they invoke
Well, what is their case on urgency? And that case is required to be made out in the founding affidavit. And you will find the case at paragraphs 128 to 142, pages 64 to 68. You'll see there's a topic, the heading is urgency, and there are 3 paragraphs until the convention, the Cape Town Convention is addressed, and the rest of it relates to the Cape Town Convention. So what are the grounds? They are the grounds set out in paragraph 128. I'm going to come to them. There is the fact that Westall is currently unlawfully using the aircraft. That's in dispute. We say that the cancellation or termination is not good, so that doesn't advance the urgency. The English courts are going to take 14 to 20 months. That's got nothing to do with urgency. If they're going to take 14 to 20 months, that doesn't mean you go for interim relief urgently. You go for urgent relief if it's urgent, otherwise you go in the normal course.
They could have
And-
sought an injunction in the case.
Indeed so, yes. And then the convention, the Cape Town Convention, I'll come to that in a moment. Now, in 128, there are a number of grounds set out. In fact, let me just put this convention to bed very quickly, so we don't have to come back to that. Our learned friends rely upon the Cape Town Convention for urgency, and they say that South Africa is a party to the convention. and relief must be granted urgently. We've agreed to it, and so on. Now, what they haven't told you, they tell you a lot about this convention, and they refer to Article 17, it's page 67, about the sort of relief that you can get under the convention. But what they don't show you is Article 14. I just want to read it to you. It's not before you, and I'll try and get a copy to you, my lady. Sorry, in urgent matters, sometimes these things slip through. My learned friend has got. I want to read to you from Article 14, and it is entitled Procedural Requirements, and it says, subject to Article 54.2, and you needn't worry about 54.2, any remedy provided by this chapter, and Article 13 is in this chapter, and Article 13 is what they rely upon. So the Article 14 says, any remedy provided by this chapter shall be exercised in conformity with the procedure prescribed.
I just wanted to give you the bundle of authorities. The applicant's bundle, am I right?
Yes, lady, if I could be of assistance, it's in our bundle of authorities at page 475.
Thank you.
Yes. My lady, I'm drawing attention to Article 14, which follows Article 13. Article 13 being the provision upon which they rely, that they can come to court for interim relief. Article 14 says, any remedy provided by this chapter shall be exercised in conformity with the procedure prescribed by the law of the place where the remedy is to be exercised. So when they come to a South African court, this remedy is to be exercised in conformity with the procedure prescribed by our law, and therefore they are in exactly the same place that they would have been had they not referred to this. In other words, they must make out a case for urgency if they want urgent relief. So we say that this convention doesn't assist them at all.
So it basically doesn't trump our rules.
No, it doesn't. So then, my lady, we're down to paragraph 128, and the grounds set out in that paragraph. That's the case for urgency on the papers. We're down to paragraph 128 at page 64 of the
convention away now.
Yes, my lady.
All right. Kapton Convention Centre, where is that? Okay. So page, what was the page?
Paragraph 124, 128, page 64. There they set out the grounds of urgency, the ones that are not yet addressed, and they say the urgency of this application is manifest for the reasons traversed in the rest of this affidavit. Now that's impermissible, actually, but there's not a problem because I deal with it. I'll show you elsewhere where they try to touch on urgency with where there is no merit to it. But what they say here, and it's not manifest in our submission, it was precipitated by the latest information which came to the applicant's attention and which has been withheld by the Gupta respondents. In particular, this includes the events of default. Now, I've taken you through the events of default. It's old hat. They've known about that for a long time. Westhorn's subsequent refusal to deliver the aircraft. Well, the refusal is because they say you haven't validly terminated and we don't accept your termination. They have a remedy. They can come to court and they say they prove the termination is good. If they succeed, they can get the aircraft back. That doesn't make it urgent.
Okay, so sorry. So they say that they were entitled to seek compliance, but you're saying it was quite clear that
in the normal course.
The respondents would never
Yes.
Even the litigation that already been launched.
Indeed so. Yes. So So come to court by all means in the normal course, not by way of injury. The disablement of the public tracker of the aircraft, inadequate response to the 2 February letter, Bank of Baroda's imminent withdrawal, and the raids on the Gupta households and the dairy farm. I'm going to deal with each of these. Now, what you won't find in these papers is where they address the fact that they cannot get substantial redress in due course. It was alluded to by my learned friend. He didn't tell your ladyship where to find it on these papers, because you won't. And that is fatal to their application. And they need to show that they can't get substantial redress in due course before they can come by way of urgency. They don't deal with it, and they don't make out a case for it.
Well, I mean, do they equate substantial, the fact that they can't, well, do they equate that allegation with irreparable harm?
Well, the cases say that they're not the same thing.
They're not the same.
Yeah.
But it seems like the applicant hates those two.
Yes, and that's wrong. You can't do that.
Those two concepts.
The law is clear on that.
Yes.
For urgency, you must show that you won't get substantial redress in due course. To get an interim interdict, you must show that that there's.
So must you pertinently you've got to pertinently address that issue.
You should,
right?
yes.
Nowhere on the applicant's papers
It's not there.
is that conclusion made.
No.
Yes.
So these events that they rely upon, in our submission, not one of them makes it clear that they can't get substantial redress in due course. They have counterclaimed, or they say they are counterclaiming in the English proceedings. If they are counterclaiming in the English proceedings, it is for the permanent final termination and return of the aircraft. So that means that they recognize that they can get substantial redress in due course, because that's what they're going to do. They're going to seek it in the English proceedings. They wouldn't do it if it was futile.
Well, that hasn't been launched, am I right? That court counterclaim. That hasn't been.
They haven't filed their counterclaim as yet.
They've not launched. They haven't filed it. Yeah. Yes.
As I said a moment ago, the refusal to deliver the aircraft doesn't make the application urgent. That's completely illogical. Disabling the tracker, they made a big fuss about that. Well, what is the most probable inference to be drawn from the disabling the tracker? They don't want interference from EDC in their travels. They've taken the view that EDC's termination was unlawful. They've instituted proceedings in...
So why don't they say that? Why don't they say that? Or is that said in the answering papers? The reason for...
Well, what we do say, my friend will get out for me what we do say on that score. My lady, the question is, what inference do you draw from that? And for the applicants to rely upon an inference that they're going to either fly the airplane into the ground, or they're going to commit some unlawful act, there must be some basis on which they're going to do that, and it's highly speculative. And my submission to you is that the most probable inference is that they just say, have taken the view they don't want interference from these applicants grounding the aircraft if it lands at a particular point one day. For example, if it came into Lanseria, you'll probably find an application that day trying to prevent it from flying out.
I'm not sure that that's the most probable inference, the most plausible inference, Mr. Cook. I mean, given that one brother is a fugitive from the law, and others in the family may be charged very soon, and I beg your pardon? Yes.
Again, this is media coverage. I don't know how reliable it is. It seems that one of the brothers is not in South Africa at the moment. He doesn't need the aircraft, therefore. So.
Well, the aircraft's probably dropped him off wherever he is.
Well, again, we don't know that. And with respect to strangers to.
Well, no, I'm not. Yes, I'm just. I mean, I'm just. There's a pungent kind of possibility that it could have been used for illicit purposes.
And there's the fact that they asked and they were told, and they now complain that they're not getting a daily report. Well, have they asked again? Maybe if they ask, they'll be told again. And they're puzzled by the fact that they're only given information up to a particular point in time. Well, an aircraft, if it's flying between Dubai and India, it won't be at one place for any extended duration if the aircraft is in continual use. And they say it is in continual use. That, of course, is good for an aircraft because that's what they're supposed to do. They're supposed to fly, and that's how they get maintained, and that's how they...
When aircraft are stationary, they depreciate rapidly.
Exactly.
Is that what... I mean, I would need an expert to give me that evidence. Eh?
Well, that's their case without an expert, and
well.
our case without an expert is that that's wrong. This is not a taxi we're talking about. It's not a car on a South African road. This is an aircraft, and if it's in continual use, the aircraft means that aircraft is being properly maintained, because there are very rigorous regulations around maintenance of aircraft, and we live in that sort of global village. These regulations are enforced.
Why the resistance to return the aircraft? Well, why the resistance to ground the aircraft, either here or in the UK?
The very first,
given the termination of the agreement.
If you ground the aircraft, it starts to lose value. Mm-hmm. And maybe we need to get an expert to tell you that, but that is the position with an aircraft. The last thing you want to do with an aircraft, if you want to maintain its value, is ground it and put it in a hangar.
And that's the reason which the Guptas then, that's their reason in the affidavit, am I right? For not returning. Do they pertinently say that this is why we've elected not to return the aircraft to EDC?
They say they have a lease, it hasn't been terminated, and they're entitled to use it, and that's what they do.
But ordinarily, I'm just thinking of the case of motor vehicle, there's a dispute, the motor vehicle is returned, kept in a safe place, and the litigation proceeds.
Yes.
There's nothing unusual about it. It happens all the time. Why should it be different with an aircraft?
Because an aircraft is different to a motor vehicle.
Certainly, I accept that, but I'm not convinced that an aircraft that is stationary and that as well is maintained. I mean, obviously, there's any aircraft that the aircraft would have to be maintained pending the finalization of the litigation in the UK, given that the applicant has an interest in realizing that asset.
The unfortunate reality is here in this urgent court. Neither of us has expert testimony on this. And my submission to you is that they are wrong, and that the case is the reverse. But whether that's a matter of sort of general knowledge or not is questionable. My lady, but more importantly, it's not material to the question of urgency and whether they were entitled to come urgently, because there's no suggestion that between today and 2 or 3 months' time, when a matter could have been heard in the normal course, that something would have had to happen to this aircraft, and that's really what they should be addressing, which they haven't. So they rely upon the removal of the tracking device. They say that there was an inadequate response to a letter sent on the 2nd of February That letter asked for information about the aircraft, and as you've seen, there was a response. It's at page 421. If I can just take you there briefly. It's Annex FA 31, and there, without reading the whole letter, my lady, you can see that...
31.
Yeah, 431, sorry, 421, my lady, sorry. Annex 31, page 421. It's a letter by Jones Day, and they say the aircraft is being well maintained and operated in accordance with the terms of the lease, other contractual arrangements. It's in good condition, it's being preserved in all respects as required under the lease, the facility agreement, and so on and so forth.
Reading from
Page 422. They give some information about the movements of the aircraft. That's in paragraph 8, in that first paragraph under paragraph 8. And they give information about release certificates and the logbook and so on. This is the sort of information you get concerning an aircraft to show that everything's up to date, being maintained, being properly used, and so on.
and in the next paragraph, any action to
Yes. Well, that 5-day period, I mean, with respect to my little friend, that's in England, in proceedings which have been instituted there, they're pending before that court. 5 days, quite frankly, not adequate for a respondent in this court in these circumstances. So, I don't understand how this response, if it is inadequate, makes this matter urgent and makes it so that they will not get substantial redress in due course. It just makes no sense with respect. The next ground is the departure of the Bank of Baroda. That's the next point in paragraph 128 of the founding affidavit. Well, what is the significance of the departure of the Bank of Baroda to the safety of this aircraft and whether they will get it if they get an interim order? There's no connection. Apart from all else, they have said they won't receive any further payments. You will find that...
they refuse to accept further payments, right?
There's a letter which says, we are not invoicing you and we will not accept payment from you. FA 26 at page 392. So the fact that we don't have a bank really has got nothing to do with anything. And then the last ground in paragraph 128 is that there was a raid on the Gupta household and arrests have been made. With respect, I cannot conceive of how those facts make it urgent for this aircraft to be grounded. So that is the case they make out in the founding affidavit. We say it's completely inadequate. If you look elsewhere in the founding affidavit, where they say it's manifest from other allegations, there are a few other passages which I should address. In paragraph 101 at page 55, if I could just take you there briefly. They say that the applicants were, until very recently, unaware of...
Sorry, page 101?
It's paragraph
101, page 55.
55, yes. They say the applicants were, until very recently, unaware of any concrete evidence of serious wrongdoing by the Gupta respondents. Now, maybe what saves them is the word concrete. They were certainly aware of the allegations and would have been aware of them for years. They entered into this transaction aware of these allegations. The very same allegations that are circling around at this point in time, the very same allegations. Then they say in paragraph 103 over the page 56, if you just have a look at that, they say, this is an extraordinary allegation. Now that the applicants are aware of the Gupta respondent's conduct as set forth above, it is endeavouring to take steps to ensure the grounding of the aircraft. What are they aware of now? There is no difference in the stature, in the character, in the nature of what they're aware of now, or were aware of in December or January or October of last year. What they're aware of is allegations in the media. No court has determined anything as yet. There's a state capture report of what they refer to in their own papers. Yeah.
It was crystallized in February, prior to the launch of the application.
It crystallizes in February in the form of an ex parte application. Ex parte application is allegations put before a judge that he threw out today.
Okay, that's the, yeah, that's
Then there's
ex parte, right?
Then there's this question of the innocent owner defense. Now, we submit that criterion cannot make this application urgent. It can't make a difference to the authorities whether the applicants bring this application urgently or in the normal course, whether they are going to succeed in an innocent owner defense or not. Either they're an innocent owner, in which event they should succeed, or they're not an innocent owner, in which event they will fail. That can't determine whether or not you can come to court urgently. Then they've raised as another factor in their papers, paragraph 105, I'm just going through random factors which may be relevant on these papers to the question of urgency. And in the process, I'm addressing what our learned friend addressed. There's a question of damage to the aircraft. Well, that's also, with respect, a very bad point. The aircraft is insured. Aircraft, from time to time, do get damaged. When they get damaged, the part gets replaced, and then it takes off again, and all is well. There is insurance in place. That is common cause. If there wasn't insurance in place, there would be an outcry. You can assume that. This aircraft, there was something about the damage to the aircraft. In fact, it's been repaired. That's what you saw. The fact that the winglet got damaged doesn't mean that they're not going to get substantial redress in due course. It's one of those things that happens, and then what happens when there is damage, it gets repaired, and the insurer pays. Then, as far as the allegations of irreparable harm are concerned, made in respect of that element of the interdict application, insofar as one can say that there's anything there that may be material to the question of urgency, I just wanted to address that quickly. Yes. And my learned friend has used some of this in relation to urgency. Reputational damage is one of the elements. Well, EDC's reputation is questionable at this point in time. They entered into this transaction with the Guptas in 2015, and the fact that they now want to extricate themselves because Mr. Poplak writes an article that they don't like doesn't mean that they can come to court urgently. And urgent relief is not going to restore their reputation, that's for sure.
But the article also claims that all of these events took place May 27 and before, so...
Yes.
And it's hardly an article that wouldn't have come to their attention, because
Well,
it's a critique of their conduct.
Yes.
Well, certainly EDC, not Stone River. Well, Stone River, I suppose, is also...
But the Canadian media, it's in our papers, we say that they got access to all of this over there, and it's not disputed. Diminution in value. Really, is this aircraft going to suffer a significant diminution in value over the next few months? With respect, that is a very weak argument. We submit that the value is maintained by the aircraft being in use. Yeah, and it's just speculation on their part that there would be a depreciation over the next few months. One of the other points raised is that there's a flight risk. That, with respect, is nonsense. You can't talk about there being a flight risk when you're talking about an aeroplane which is not in the country. If the aeroplane was at Lanseria Airport and they came to court in a rush this afternoon and said the aircraft's there, we've got grounds to keep it here because this is our case, then you can say there's a flight risk because if I don't get my relief, they're going to leave with it. When it's not here, flight risk is irrelevant. And then in the replying affidavit, they add to the grounds of urgency. We say this is inadmissible, but I'll address those grounds quickly.
Sorry. Oh, you said they added in their replying papers, yeah.
So in the replying affidavit, they say that critical events came to the applicant's attention in January 2018. That justifies the urgency. What are the critical events? Poker and Eskom. I've dealt with those. Poker's out the window. Eskom happened in January, and it relates to events which are all well known and traversed in the media ad nauseum over the past years. They say the allegations of turpitude and impropriety have crystallized. That's paragraph 14 at page 1397. That is pure sophistry. Where do they get that from? They've crystallized. How have they crystallized? No judge has given a judgment. That might be a crystallization of these allegations, but that hasn't happened. All we have still is allegations, media reports. Nothing has changed. So we submit that this is a faith-saving endeavor to salvage a damaged reputation, and they've rushed to court, and it's an abuse of the process, and this matter should be struck off the roll. Then there's a question of the merits and the strikeout, and perhaps I can ask my Leonard Jr. to address you briefly on the strikeout application. Thank you.
Lady, in the interest of saving time, I'm going to really address the real prejudice that we stand to suffer, and that is the new breach alleged in the replying affidavit. That's paragraph 64 and 65 onwards, read with annexure RA7 on page 15.
Paragraph 60.
64 and 65, where really a new breach is alleged.
This is of the replying
Of the replying affidavit, yes. It is alleged that there was a failure on the part of Oak Bay to provide its audited financial statements for the year ending 28 February 2017. It's not an issue which was raised previously in the founding papers, raised for the first time in reply pursuant to a termination notice dated the 23rd of February 2018. We submit...
Sorry, so this was relied upon for the February notice?
It's the February notice. The ladyship will not see...
There was a further notice, 3rd of February or something, no?
It is a further notice.
Yes,
the
yes.
specific ground alluded to in this notice, your ladyship will not see that in any of the preceding notices for the months of October,
Yes.
December, or in fact the January 25 termination notice. This is something completely new.
Okay, so the fact that it's relied upon for a further notice, does that not make it relevant?
It makes it,
Yes.
it makes it material and relevant,
Yes.
and it goes to the very prejudice that we stand to suffer.
For raising it in prior.
Because if we don't get the opportunity to respond thereto, then clearly, and it's evident from what our learned friend Mr. Cockrell has to say, that they do rely very much on this. It's evidence which they treat with considerable weight, and they will rely on these allegations to sustain a further breach of the facility and the lease agreement in particular in order to demand the exercise of their right to claim the aircraft back.
And the allegation of prejudice, is that made out?
They don't deal with any prejudice to us. They simply assume that we must just deal with these allegations. In fact, it goes further.
Oh, yes, you didn't respond to the reply.
Yes,
Sorry,
it's in the replying affidavit. It
You
goes
didn't
further.
respond to that, yes.
There's not an attempt in their affidavit to explain to you why it is that this is only raised now. What we heard this morning, as we understand the case, is, well, this was only raised in a letter on the 23rd of February, well after the application had been launched on the 15th of February. Of course, that is true. But one must take a step back. This letter of the 23rd of February was transmitted before our answering affidavit was due on the 26th of February. At a first level, nothing would have stopped the
Sorry,
applicants
just go
from
back.
raising this.
You're going very quickly. You're going very quickly. Just listen, to go 2 steps backwards. Sorry, just the point about. Sorry.
It's raised for the first time
It was
in
raised for
reply.
the first time. Yes, yes, they understand.
Yes.
But the point that Mr. Cockrell made about
They place heavy reliance on this
on
particular
the fact
breach.
that it was raised after the founding affidavit.
Well, their approach simply is that we haven't responded thereto, and therefore the evidence is in and it is uncontested, and we could have done so. I will deal with that in a moment. But the fact is, it is evidence of considerable persuasion insofar as the applicant's case is concerned, and if it is not struck, then we ought to be given the opportunity to respond thereto. Failing which, the risk is there that there's a finding by a court relying on a breach raised for the first time in reply, without having afforded the respondents an opportunity to deal with the issue. Now, no doubt the applicants will say it only pertains to a few crisp allegations. That might be so, but the fact is, one does not assess these issues simply on the basis of the quantity of the allegations, but there's also a qualitative component, and that is one needs to consider one's position carefully, one needs to assess the allegations and proffer a response thereto. All of that takes time. And there's simply, the reality is there simply has not been the opportunity during the last few days to do so sensibly,
You
given
had
the
4
time
days or 5 days
constraints.
to do so.
Beg your pardon?
You had 4 days to do so.
Well, lady,
Monday.
we've, as Mr. Cook has indicated right at the outset already, we've been under extreme pressure in both preparing for the application, but also in getting heads of argument filed on time to assist the court in dealing with the matter appropriately. But there is no explanation given to your ladyship as to why this issue had not been raised previously. The prejudice that we will suffer if these allegations remain part of the papers is clear. It will deprive us the very opportunity to respond thereto. But perhaps one must give some context to this, because although the issue is raised for the first time in their letter of termination dated the 23rd of February 2018, which your ladyship will find on page 1501, paragraph 2.2.
Sorry, 1501. Yes, let me just get there, please.
It's then dealt in paragraph 2.2 on page 1502.
Sorry, I've just gone blank. What is your name again? Just remind me.
Mr. Bester.
Bester.
Yes.
It's an easy one to remember, actually.
It's raised squarely on page 1502, paragraph 2.2.
So just give me 1 second, Mr. Bester.
They say that the audited financial statements of the corporate guarantor, in this case being Oak Bay,
Paragraph?
2.2,
Okay. With
have
you?
not been provided, and they refer back to the date of 6 December 2017. That, in the context of these proceedings we submit, in the context of this application, is also a key date. Because if your ladyship flips over 2 pages to Annexure R88, page 1505,
Sorry, is that the date? You're talking about the 28th of February date?
yes, they say the financial statements for the year ending 28 February
Yes.
2017 ought to have been provided,
Yeah.
and they claim that they have not been provided. What they refer to is there was a notification which they refer to in the same paragraph, dated 6 December 2017. And I'm going to take your ladyship there now on page 1505.
Sorry. Give me a moment. I just want to have a sip of water. Yes, Yes, 1505.
1501 is the letter in which they seek to place the parties in mora,
Yeah.
as it were. RA 8, page 1505. And your ladyship can simply turn over the page to, and this letter is dated the 6th of December 2017. Paragraph 2.1. I'm simply going to read from the last sentence in paragraph 2.1. So the 6th of December, they say, we hereby require the borrower and the corporate guarantor to remedy such breach. And the breach in question, my lady, is the failure they claim to furnish audited financial statements.
You're reading from, where are you reading from? Sorry.
2.2, the
Oh, beg your
2.1,
pardon.
the last sentence.
Okay, just slow down.
Is the
Slow
court
down a
reads.
little bit, okay? I'm finding it hard to keep up with you.
What they say is on page 1506. This is the letter
Yes.
in terms of which they place us in mora.
Okay.
The last sentence, they say, we hereby require the borrower and the corporate guarantor to remedy such breach and provide evidence to the agent of same within 30 days of the date of this letter. So, in effect, if they are correct on these allegations, the event of default would have crystallized already on the 6th of January this year. And this is where it becomes important, because it demonstrates that they've held back this additional breach referred to in the replying affidavit. In the letter of termination of the 25th of January, nowhere will one find reference being made to this particular breach. So they had the opportunity from the 6th of January 2018, when on their version the event of default crystallized, to take this further and to cancel the lease agreement on this basis. They do issue a cancellation letter on the 25th of January this year, but this breach isn't raised.
Good.
They held back on this, my lady, for no explanation whatsoever. The termination letter is only issued on this breach on the 23rd of February, and the issue is then pertinently raised for the first time in reply. So we submit that is manifestly unfair to the
You're
respondents
saying it
of
was
this
a
instance.
deliberate holding back?
We submit it is, with great respect, in the absence of an explanation in the replying affidavit as to why it was not done and why they did not consider it necessary to either raise this in early January or in the January 25 termination notice, or for that matter by way of a supplementary filing affidavit just before we were due to file our answering affidavit, in order for us to deal therewith issuably in our answering affidavit. In the absence of all those explanations, we submit that this was deliberately held back in order to create great prejudice to the respondents, to deprive them of an opportunity to respond to these allegations. I just want to briefly touch also on the report that they rely on from the National Treasury.
All right,
I'm not
just give me
going
one
to
second. Let me get some of this down. Yes, sorry.
Of course, before I get there, as an aside, our learned friends for the applicants simply argue also, and they quote from Erasmus to say, well, we must simply plead over. But it stands to mention that our opportunity to plead over has come and gone. We had one bite at that cherry, and that was when we filed our answering affidavit. It does not follow that we can simply file a further affidavit as and when we please. Otherwise, one
Oh,
would imagine that...
you could have sought leave from the court.
Of course we could. But the fact is, at the time at our disposal, it simply has not been possible to deal with these very important allegations in a meaningful and sensible manner. Although, as and when a new breach notice is
But
issued...
Mr. Bester, we all, we accept briefs as lawyers, and when you accept the brief, you are expected to basically do what has to be done,
Of course.
Despite the time constraints. So I'm not sure that that's a valid explanation to say that we really didn't have the time, because we were doing this and that and whatever else. That's why juniors are in the matter. You have...
Oh, no, of course, that is indeed so, my lady. But
Clients like yours, you could have had.
the reality...
I won't blame the silks here, but
The
that's what
reality of the
juniors are
matter,
for.
the reality of the matter is that the allegations have not been dealt with. But there's another point to be made, and of course it's only necessary for us to deal with these allegations as and when the applicants have made out a case to this court as to why they should be permitted to introduce these allegations. They simply haven't done so. They simply just glibly slipped them into the affidavit without having endeavored to make out that case. And we submit only once they've overcome that hurdle would it be necessary for us to file a further affidavit, and not before then. Very briefly, if I may just refer to the report Also next as part of the replying affidavit, it makes reference to a report by the National Treasury, an investigation which they are said to have conducted. Again, this is additional material raised for the first time in the replying affidavit, and
All right, just give me a second, sorry. So just give me that again because I was on
it's
the...
Annexure RA6, page 1464.
Yes, I'm with you.
Ladyship can keep your finger open at that page, but also look at page 1409, paragraph 61, where they make reference to the report in their replying affidavit. They say that, I understand that the allegations of unlawful conduct set forth in the ESCOM proceedings are corroborated by a report of the National Treasury. So, unlike their
So
answering
it's
affidavit,
1409, paragraph
61.
61.
So unlike what they now say in their response to the strikeout application, that they're simply relying on the fact that a report by National Treasury exists, they in fact go further in their replying affidavit, and they say they specifically rely on these allegations as corroboration of the existence of unlawful allegations made against the respondents. So it's not merely the existence of the report, it's the contents of the report upon which they rely on. And it's problematic for two reasons. Firstly, it's new matter. It's quite a lengthy report, no
Yes,
doubt.
that was attached to the replying.
To the replying affidavit. It's a report which exceeds 42 pages, which we haven't had the opportunity to respond to. And also, of course, it's hearsay matter. I don't believe there's any dispute on that score. What our learned friends, however, do on that leg of the case, they simply contend that your ladyship should exercise your discretion by admitting the evidence. We say that's problematic. We say so for the following reasons. Firstly, the report itself is undated. It's not clear who the
So they
authors
say we
of
should
the
admit it
report
in the
are.
interest of justice?
Yes. But with respect, it's not quite as simple as that. There's no indication as to who the authors of the report are. That isn't highlighted anywhere in the report. It's not indicated when the report was prepared. And moreover, what steps did they take to, at the very least, make contact with individuals at National Treasury, the basic investigative functions that one would expect a party to perform before submitting a document of this nature before these proceedings? Who did they contact at National Treasury to get some insight into who the authors are? And to the extent that they were unable to do so, what further steps have they taken? So, quite frankly, we submit that in the absence of these very basic building blocks to establish and gain insight into the veracity of the report and who the authors were, or at the very least then to, if they established who the authors were, to obtain confirmatory affidavits from them. In the absence of them taking this court into their confidence by dealing with those basic matters, we submit that your ladyship should not exercise her discretion by permitting the report to form part of the record in these proceedings. We accept that there's a discretion given to a court to be exercised judicially, but it simply does not follow that one can, because serious allegations are made, glibly slip in a report of this nature without the applicant having taken the court into its confidence by saying what steps have been taken to ascertain who the authors were and why it is that they cannot put some corroborative evidence under oath before this court. So on those grounds, we submit that the report itself should be struck from the record as well as the paragraphs in the finding affidavit. I'm not going to deal with the POCA proceedings. It seems that subsequent events today have overtaken that, and Mr. Lana will address you more fully on it. But those are really our submissions in support of the strikeout application, and we would then seek an order in terms of the notice of motion.
Thank you. Thank you very much. Thank you, Mr. Weston.
My lady, ideally now we would have wanted to ask you to strike the matter off the roll, but I suppose I have to address the merits of this
Yes.
application. I'm going to do so briefly.
Yes.
My lady, my Linda Junior, late last night, working very hard, sent me...
You did a pretty good job too today.
Yeah, indeed so, I agree. sent me 2 cases, and I'm going to give my learned friends a copy, and I'm going to give you a copy of these. They're 2 English decisions. I'm not going to spend a great deal of time on them. I just want to allude to the principle in these decisions, bearing in mind that the merits of this dispute are going to be determined in an English court. And what the court has said in these 2 cases, where the later one refers back to the earlier decision, the Rice versus Great Yarmouth Borough Council refers back to the I can't read the name here, Anteos Compania case. And the judge passed comments such as this, which I'm just going to read to you briefly, that there has long been a tension in the world of contract.
Sorry, what page are you reading from, sir? Sorry.
I don't know, my lady. I'm reading from my learned friend's work at midnight last night.
Oh dear, okay. Can you help us, Mr. Bester?
So I'm just reading a principle which I'm going to...
But are you... Sorry. The pages are numbered.
My learned friend will try and get it while I'm reading.
Okay, sure.
There's long been a tension in the world of contract between an attachment to literal meaning that makes for certainty with all in black and white, and the parties knowing exactly where they are, and little room for the relative unpredictability of judicial intervention, and a desire to avoid consequences seen as unfair or seen as offending commercial common sense. And then there's a further passage that in the context of a contract intended to last for 4 years, involving substantial investment, or at least substantial undertaking of financial obligations by one party, and involving a myriad of obligations of differing importance and varying frequency, I have no hesitation in holding that the common sense interpretation should be imposed upon the strict words of the contract, and that a repudiatory breach or an accumulation of breaches that as a whole can properly be described as repudiatory are a precondition to termination pursuant to clause 21.2.1 in that matter. The point that is addressed in these 2 judgments is that where you have a commercial contract such as this, involving a lot of money and many intricate clauses, you have to apply some commercial common sense to the contract, that you cannot have a situation where the lessor can cancel this agreement with huge prejudice to the lessee, who has already paid out up front to Bombardier a sum of $10 million. So huge prejudice flows from a termination. You can't have a termination that arises out of the fact that a financial statement arrives late, or that a party is no longer the chairman of the company, which is the corporate guarantor. You can't interpret a commercial instrument of this nature in that fashion. This is not the correct court to determine this.
Justice Wallace has said that in the Pensions Fund case. Am I right? The commercial sense interpretation.
Indeed so, my lady. So the question of interpretation of this contract is something that will be determined in the English courts. And there it will be argued, as is apparent from the particulars of claim which are in these papers, where you see there's a very detailed claim, where where Westbourne goes into these various breaches and asserts that these breaches are not good because most of them are not material. And the material provisions really are those relating to whether you're paying the price.
So you say whether you meet your payment obligations.
That's the material clause.
Yes, but the way I understand the contract, there are 2 sets of obligations. Am I right? The one is your payment obligations, and the second is certain reporting obligations.
Yes, that is so.
So,
and when you look
so
at
you're saying I must basically. You're saying the only material aspect would be the aspects would be the payment.
The rental is the material aspect, but the others I'm not saying are not material. But you have to look at the materiality of the basis on which a party terminates the agreement. so that you should look at whether this breach upon which the applicant rely, and there are many, for example, the lien. How are you going to interpret the provision about the lien? A lien was granted in 2008. It might have absolutely no impact upon the state of affairs at all. Do you seriously contend that the lease agreement of this magnitude involving these figures that has been in existence for years, where a huge amount of money has been paid to this lessor, can be terminated because of that oversight, perhaps, if it was? I don't know what the facts are.
This is an agreement, these are clauses that were agreed to by the parties.
They are.
You know.
They are there. We can't get away from that. My submission to
Knowing
you
full
is
well that there were liens granted in 2008 and 2011.
Yes.
Prior to the conclusion
Yes,
of this agreement.
there's an interpretation question there, which will be argued obviously in the English courts, and there's a question of whether the applicants in fact knew about that at the point in time. In answering the affidavit, they say that the respondents say the applicants did know about it. So those are the sort of issues that are going to be determined in the English courts. There's a case made out to dispute these various grounds of termination, the events of default, and our submission is that in the light of these disputes, that serious doubt is cast upon the basis on which the applicants come to court, and if serious doubt is cast upon the prima facie right, then they should not be entitled to prevail. I'm not going to address it further than that on the question of prima facie right. Then there's the question of irreparable harm, and we submit that there will not be irreparable harm by the respondents continuing to use the aircraft, because if you use an aircraft, you maintain its value and you maintain the aircraft, and that there is no real risk of damage. The sort of damage that has arisen here is the kind of damage that can happen from time to time, but if there is damage, the damage is repaired, the aircraft is insured, it's not going to...
Well, I suppose you have to maintain the aircraft, otherwise
yes.
you could be be killed.
As I say, my lady,
Yeah,
we don't have expert evidence about what happens with an aircraft in a hangar. Yes. And of course, whilst the respondents use this aircraft, and the point is made in the papers, that obviously they're going to see to it that it is properly maintained, because they are the ones using it, and it's a matter of life or death that if you fly in an aircraft, you want it to be in peak condition. Well, I certainly do. So we submit that there is no irreparable harm that will be sustained. The question of another remedy, there was an attempt to purchase the aircraft, which was rejected by the applicants. They say that...
But was that a real attempt?
It wasn't a good attempt. They could have done better, because they did it on a conditional basis, which they shouldn't have. But the point is this, that it was never explored, and it's something that could have been explored, and something perhaps is still capable of being explored. The acquisition of the aircraft by either Westbourne or some other entity, because that's the basis in which it was put, that another entity would acquire the aircraft, that certainly would be an alternative remedy. But that is something that they just rejected out of hand.
But I mean, certainly, if you're going to... I mean, that purchase would obviously need the consent of the of EDC, right? The finance.
Yes, obviously.
The financing agent, yes.
It's something that they could have pursued. It's something they could have taken up. They could have taken up the offer if the money was going to come from a third party, as indicated by the exercise of that option. They wouldn't have a problem with the money, and it's another solution to the problem, which they didn't look at and simply rejected. And we say that they should.
Well, I mean, I think the point was made that that offer was deficient because it didn't meet the notice requirement, I think, which had been 6 months.
I agree
You
entirely.
agree, okay,
It
okay.
wasn't compliant with the contract, yes. Well, lady, but our principal argument is that the case for urgency is extremely weak. You shouldn't allow this abuse of the process, and notwithstanding the individuals involved applying the law, you should, with respect, come to the conclusion that this matter should not have been brought as a matter of urgency. We ask that the matter be struck off the roll, and we ask for the cost of 2 counsel. Thank you.
Yes, Mr. Barner.
Thank you, Lady.
I'll just get a different pen.
Lady, the elephant in the room, which the applicants don't want to face,
So,
is this.
give me 1 second, Mr. Barner. Mr. Cook, just the references in the rights judgment that you relied upon.
Oh, yes.
If you can just let me have that, if you.
It's page 5, my lady,
Yeah.
of the rights judgment.
Yes, page 5.
Thank you, ma'am.
Okay. My apologies, Mr. Barnard. You may proceed.
No problem, Lady. I started saying the elephant in the room, which the applicants don't address, is why they don't go to the English courts for injunctive relief. They tell your ladyship they'll institute a counterclaim there, but one has to ask, why do they not follow the jurisdiction clause that they insist be inserted in the contract for their benefit? Why do they not go to the English courts where the matter is already pending? And why do they not go to the English courts who can probably give more effective relief here? Certainly not the type of conditional relief which they say that if the English courts find against the applicants, then the order can be reversed. And the answer to that, my lady, is that the applicants really have engaged in the worst kind of forum shopping. And why we say that is that one can think only of 2 real reasons why they don't go to the English courts. And the one is the hope that the South African courts are so poisoned against the Guptas that one just needs to throw around the name Gupta and a few allegations of corruption and impropriety, and the judge is already influenced into granting an order.
I have no doubt that they would face a similar response in the UK, given the involvement of Peter Hay.
Well, that's Lord Hay, my lady. But of course, it's not.
The English
whilst
UK
it's
Parliament.
in the news there, it's not all pervasive as it is in this country, where every day there's a headline in the paper regarding the Guptas. But the equally significant reason, my lady, and if one is to find a relatively innocent reason, is this. And that is they know that they have a higher threshold to meet in the English courts. And we say that not because the requirements for injunctive relief may be that different, but because when they go to the English courts, there is already a pending matter in that court where the validity of the termination is squarely challenged, where the proceedings already there in the form of a declaration. And they can't get away with what our learned friend Mr. Cockrell opened with, and that is, you're going to decide this case purely on the prima facie right.
You say they can't get away there?
No. Because
the matter
there's
is
a pending matter,
pending
there
there.
are particulars of claim. They've got to deal with the challenge to the effectiveness of the termination. And if there are any other reasons, my lady, certainly the applicants haven't explained to the court why they don't proceed there. But it's not...
So are you saying this was what? Political opportunism?
No, it's
to
either,
take
it's
to
either
take advantage of the
political,
political climate here.
yeah, it's either the one, or they hope to tell your ladyship that this is simply an interim interdict, and all you've got to find is a prima facie right, which is a very low threshold, and they cross that threshold. Now, our learned friends for the first and second respondents have addressed argument on the assumption that the applicants need to show a prima facie right, but they of course do so, the first and second respondents, on the basis that even on that low threshold, the test is not met. But we wish to draw your ladyship's attention to a different point.
Okay, can I just get this one? The issue of jurisdiction. I know you took the point in your heads.
I'm going to come
And
to
the forum convenience and non-convenient, how do you say it?
that. Yes.
No convenient, I suppose.
I'll defer to your ladyship's pronunciation.
From my French 1 lessons about 25 years ago
It's more
at
than enough.
university. Eh?
I'm going to come to jurisdiction. But the point we want to put up for your ladyship's consideration is whatever the applicants say that it's a prima facie right, and even the way the matter has been argued, is you've got to look at the real essence of the relief. And what is dressed up as interim relief is in fact relief that is final in effect. And therefore, this approach that the applicants take, that all they need to show is a prima facie right, is not one that is axiomatic. Your ladyship will have regard to the form of the relief that they seek. You'll have regard to what the Supreme Court of Appeal has said in the Metlika decision, which they rely on, which I'm going to take you to, and you're going to have to ask yourself whether this is truly interim relief. And when your ladyship does that, we submit your ladyship will come to the conclusion that this is in fact not truly interim relief. And the significance of that is that the test is not the simple prima facie right that our learned friend Mr. Kapton waved in front of you when he opened with his submissions. And one of course goes to the notice of motion, and we make this point up front. The fact that relief may be for a limited period does not make it interim. So,
Well, I need to understand why it's not interim. I mean, it's for the return
Because-
of the aircraft, ground the aircraft.
because the question as to whether it's interim or not, the test is whether this court will ever revisit that issue. A court in South Africa will ever revisit the issue. I'm going to take your ladyship to the test in Metlika, which will put clarity on that.
So are you saying that in the event that the UK court finds that the termination of the agreement was unlawful,
Well, they
the
are.
plane is stuck here? Well, the aircraft is basically here.
It's not whether the English court may make some pronunciation. The test of interim relief is whether a court in this country will ultimately revisit the issue. And I'm going to take your ladyship
Yes.
to that in a moment. I just want to take you to the notice of motion.
Yes, but let me just get there, Mr.
To clarify the next submission on that.
Just give me a minute. I want to find. I think you guys are going to help me here with just closing up some files, because I think we dealing here with the law. So just give me the first file with the notice. Give me that. Thanks. I can just close these up and put them one on top of the other, so if they need them, I can just. Yes, Mr. Barner, I'm at page 1. Notice of motion.
So if your ladyship will go to page 2, and your ladyship sees that what they ask for is, they say, pending the final determination between the first respondent and the applicants in the English proceedings, which they then define as the interim period, and the relief then where they subsequently get to the substantive relief is all tied to the interim period.
Mm-hmm.
When your ladyship has regard to paragraph 2.1, notwithstanding that the relief may be for what they would seek to argue is a limited period, your ladyship sees that what is sought is the delivery of the aircraft for custody in the United Kingdom, alternatively to Nigeria. Second paragraph, again, pending for the interim period they require possession. And over the page, The point that illustrates it even more clearly is they seek the deregistration of the aircraft for the duration of the interim period.
Yes, but that is, sorry, that's in the event of non-compliance.
Yes, it's alternative relief, but
Yes,
it's
alternative
certainly,
relief, yes.
it's certainly the relief that they seek.
I'm still trying to understand why this becomes final relief. So you are saying the question, you're saying that
The first submission...
that depends on whether or not this court can actually,
Yes.
the South African court can revisit
Yes.
the issue of the
And
relief.
that
Okay.
test, Milady,
Yes.
I said I'd take you to Metlika,
Yes.
that if you can have regard to a decision of the Supreme Court of Appeal in Pitelli, P-I-T-E-L-L-I, versus Everton Garden Projects, 2010, Volume 5, SA Law Reports, page 171, a decision of the Supreme Court of Appeal
Yes,
at
is that
paragraph 27.
Justice Nugent's judgment, am I right?
I've just got the extract. I'm not sure if it is Justice Nugent. Will check on that. And what is said there is an order is not final for the purposes of an appeal merely because it takes effect unless it is set aside. It is final when the proceedings of the court of first instance are complete and that court is not capable of revisiting the order. Now, although said in the context of appealability, the point is still that it's not simply...
Sorry, so you're saying it is not final for purposes of appeal? Just say that again to me. So I know that judgment, but I'm just trying
I've now just put the extract away.
I need to understand this.
Yes.
Mr. Barn, I need to understand.
It's not final merely because it takes effect until it is set aside, or read the period, that what they call the interim period expires. It is final when the proceedings of the court of first instance are complete and the court is not capable of revisiting the order. And that is the case here. No South African court is ever going to revisit this order. Certainly this court of first instance is not going to revisit the order.
Sorry, it becomes final when the proceedings in the court of first instance are complete.
Complete, and that court is not capable of revisiting the order. We say the proceedings become complete in South Africa when your ladyship grants an order here. And then in the Metlika judgment, it's, I think, in our learned friends bundle of authorities. I don't think I've got a page number. We'll find the page reference to you. We distinguish Metlika later on a different point, but for the purposes of the current leg of the argument, if your ladyship will have regard to, and this is a case, as I say, that they rely on, page
Yes.
12 of the judgment.
Debbie, can you give me the applicants? Oh, here it is. Hold on. Yeah, got it.
So, interestingly enough, that also concerned an order seeking the return of an aircraft to South Africa, and at page 12...
So it's page, what is the paginated page
the
reference?
decision, page 12, I don't have a paginated
Perhaps your...
reference. We can find it for you.
All right, let me just, sorry, there is an index here. Let me quickly look down there. Metlika.
I'm told 179 of the bundle.
Oh, thank you. Yes,
The decision
179.
starts at 179, and I'm at page 12 of the decision, which I'll give your ladyship the paginated reference to in a minute. Page 189.
Oh, thank you. Yes. Against the paragraph?
Yes. Paragraph 24. The order that steps be taken to procure the return of the aircraft to South Africa as well as other orders relating to the aircraft, were intended to have immediate effect. They will not be reconsidered at the trial and will not be reconsidered on the same facts by the court of quo. For these reasons, they are in effect final orders. And the courts go on and deal with the case of Phillips and others versus the NDPP, in which it was held that a restraint order in terms of the Prevention of Organized Crime Act, which was considered to be analogous to an interim interdict for attachment of property pending litigation, was final in the sense required by the case law for appealability. And although those cases deal with appealability, we say the order is clearly also final in effect for the purposes of the appropriate test on an interdict.
Yes, so I'm just thinking, in the context of, okay, so pending a trial here,
The court said that
in the event that the trial is dismissed, the interim relief falls away.
the courts in
Evaporates, right?
The court in Matlika said that notwithstanding that there was going to be a trial, those issues were never going to be revisited by the trial court, and that is why that was final in effect.
Well, here you're saying we revisited by nobody,
Yes.
by no court.
All the more so here. That's exactly the point we're making. Yes, and although we've made the point in your ladyship, it's alternative relief. Yes, even before you get the alternative relief, my junior takes me to the draft order handed up, paragraph 2.1.
Of the draft order. Remember, there's the main relief and the alternative.
It's the
Yeah.
alternative.
Shall I go to the alternative?
Yes.
Thank you.
Paragraph 2.1, we use this just as a further example. What they seek is a certificate of cancellation, and in the papers we read later, they say that if the English proceedings don't go their way, then the aircraft, then the registration can be reinstated. But the point is simply that it all goes to show you how this is really relief that's final in effect, and the fact that it may be for a limited duration, what they call the interim period, should not mislead you into believing that this is truly relief that is interim. And it's trite that it's not the label that one puts on it, but it's the effect of the relief that decides whether it's interim or final. So we say that notwithstanding the submissions that have been made and the fact that the first and second respondents address the applicant's submissions to say they haven't even made out a prima facie case, the test is not simply a prima facie one, the test is as if a final interdict would be granted.
You're saying specifically in this case because a South African court will not revisit this issue,
Yes,
but not in the ordinary course of interim relief.
thank you, ladyship's point.
Pending a trial in this here, in this court
There's
or in
never
another
going to be a
court.
trial and the English courts are not going to revisit all of these issues either. They may revisit some of them, they may, but certainly not all of the issues here. Then, my lady, we're not going to re-argue everything that was argued on the question of urgency by our learned friends for the first and second respondent, but we would like you to go to our heads of argument. And we've set out a brief timeline in paragraph 16, but what would be more user-friendly is simply to give your ladyship a chronology which simply lists events with reference to the papers. There's nothing new in that, it just gives your ladyship convenient references.
Sorry, what page am I looking at?
I'm handing up a chronology.
Oh, thank you. That'll be helpful.
Going to highlight a few aspects. The more complete references are all there. If the ladyship can go to page 2 of the chronology, the line item of 16 March 2016.
Yes.
On that date, with reference to the papers, we've given you the cross-reference in the right-hand column. There's the article from the Globe in Mail, State Capture Fears Trigger Turmoil for South African President Jacob Zuma. On the 27th of May, on the next page, the article, Power of Gupta Family in South Africa as People Fear State Capture. 11 October 2016, similar articles in relation to the fraud charges against the minister. 16 October 2016, the Tuli Madansela Anti-Corruption Crusader article. The article then, the further articles that we set down, and then 17 November 2016, the notice of non-compliance from EDC to Stone River, Oak Bay and West Road. And then some of the events our learned friends have touched on across the page. There's the Execujet Aviation Termination Notice to EDC, 5 October.
Sorry, what date? 5 October.
5 October 2017.
Yeah.
18 October 2017, that's what our learned friend touched on, the notice of default from Stone River to Westbourne. And the same day, 18 October, notice of default and reservation of rights notice from Stone River to Westbourne. If you can scroll down to the 13th of December, you were taken to that, the notice of event of default. And similarly, 14 December, the Helen Suzman Foundation case, which we were referred to as a staggering claim, but if one reads the papers, it's really, well, we need to say no more about that for now, but the date is the 14th of December 2017. And then on 10 January, the proceedings in England. I think that was the date of the filing of the declaration. The proceedings themselves had been instituted on the 18th of December. And then, of course, your ladyship will recall that this application was then launched on the 15th of February of this year. We then, with reference to our heads, then make the submission in paragraph 16.1 of our heads.
Sorry, just 1 second. Sorry. Yes, sorry. Yeah. Should I go to your heads? Yes.
Paragraph 16.1.
Your heads of argument. Have I got the right heads here? Second respondents.
Yes. Would it be useful for me just to give you references to the several termination notices? I know Mr. Cook has, but I'll just give you the paragraph numbers in our heads.
Are you referring to the heads of argument or the...
The heads.
Oh, yeah, that'll be fine. There's just no 16.1 in your heads. That's what I'm... There's just 16. They just...
Has your ladyship there. It's a lot of paper. Have you got the third and fourth respondents? Urgency and preliminary issues. Heads.
Oh, I got, sorry. I'm looking at the wrong set thing. Sorry. I didn't hear you. Yes, 16.1.
Yes. You can just reference it for the moment.
Okay.
I don't have to take you to the paragraph 15.3. We deal with the second termination notice. That's 13 December 2017. The ladyship will recall there was an initial termination notice, and then the applicant said they wouldn't rely on that termination notice. So the second notice is 13 December 2017, paragraph 15.3 of our heads. Paragraph 15.6 of the heads, the third termination notice is on the 29th of January, but it refers to breaches allegedly occurring on the 14th of December and 18 January. And then in paragraph 15.7, the position of the applicants on 2 February that they wouldn't be accepting any more payments. Now, against that, in paragraph 16.1, the paragraph I took your ladyship to, we say, having regard to that brief timeline, this is dispositive of the case for urgent report. In 16.1, we point out that they purported to terminate the lease on 13 December 2017. On that date it was, as it is now, not in possession of the aircraft, and the applicant did nothing to recover possession until 15 February. In other words, it waited almost 2 months to do so. And then in 16.3, they launched, the respondents launched the English proceedings, some of them in December 2017. The applicants could then have launched their own injunction relief in England on such date. They could even have launched urgent proceedings in South Africa, assuming our courts have jurisdiction, which we deny. Instead, they did nothing further, and they've still to plead in the English proceedings. And then, if we can ask you to skip to paragraph 19, we've made the point of waiting for 2 months, where we say, given the alleged prejudice, this is irreconcilable. In paragraph 20, we say it's destructive of their case and urgency. They admit the true motivation for recently having kicking into high gear is on account of the recent adverse media coverage that has been directed at the respondents. And the article I learned from Mr. Cook took your leadership to will show that there's nothing new about these articles. And we then make the point that in argument this morning, our learned friend for the applicants then said they essentially, these were a cascading sequence of events. We submit that simply flowery language because they can't take your ladyship to the actual trigger that they say is the proper trigger for urgency. They cited, our learned friend cited 3 things. He said the damage to the aircraft. We've heard our learned friend Mr. Cook's submissions on that. We're not going to repeat that. We spoke about the reputation. We've heard Mr. Cook's submissions on that, and also the fact that these allegations of damage to reputation have been circulating for months. In fact, the Bank of Baroda, in their own decision to close the accounts in July of last year, cited all of these reputational issues. And there's then the issue that our learned friend spoke about the forfeiture by the AFU, which I'm going to return to in a moment when I deal with those proceedings. But we say that when you have regard to those 3 factors, you'll find that none of that explains the sudden urgency on the 15th of February. And there are, of course, 2 issues related. The first issue is when did all of these events start coming to your knowledge? And in fact, if there are more events later, it clearly doesn't, you don't take it from the last events to say, well, it became urgent because we then saw an article, for example, on the 14th of February, because the alleged damage to your reputation, by association, etc., would have been known far earlier. But there are 2 issues. The next issue is that even if a matter was urgent, where a party sits and does nothing, the party cannot then run to court on truncated time periods because the urgency is then said to have been self-created. And if we can then ask your ladyship to return to our heads of argument, paragraph 22. Where we refer to the East-Rock trading decision, and we've set out the relevant portion for your ladyship's convenience.
Yes, that's the decision of my brother Vepner, right?
Yes.
Citing Noche. Noche.
But,
Noche, AJ.
yeah, Vepner raises a similar point. He says Rule 612 is not there for the taking. The applicant has to set forth explicitly, and we say not just explicitly, but in good faith, the circumstances which he refers render the matter urgent. More importantly, the applicant will state the reasons why he claims he cannot be afforded substantial redress at the hearing in due course. The question of whether a matter is sufficiently urgent to be enrolled in as an urgent application is underpinned by the issue of absence of substantial redress in an application in due course. I'm going to come back to that, but your ladyship asked a question of our learned friend this morning, and your question was along the lines, where in the papers do you show that you can't be afforded substantial redress in due course? And our learned friend made certain submissions to your ladyship, but he did not take you to the papers. And of course it's got to be set out in the papers and in the founding papers. It's no good for our learned friend to make that point in heads of argument as they seek to do, or on his feet this morning. And it was significant that he didn't take your ladyship to the papers in response to a direct question from your ladyship. Before I leave the East-Rock quote, if I can take your ladyship further down to paragraph 8 of the decision. It's page 17 of our heads. In my view, the delay in instituting proceedings is not on its own a ground for refusing to regard the matter as urgent. The court is obliged to consider the circumstances of the case and the explanation given. We say you've never been given a proper explanation. The important issue is whether, despite the delay, the applicant can or cannot be afforded substantial redress at the hearing in due course. A delay might be an indication that the matter is not as urgent as the applicant would want the court to believe. On the other hand, the delay may have been caused by the fact that the applicant was attempting to settle the matter or collect more facts with regard thereto, neither of which is raised by these applicants. It means that if there is some delay in instituting proceedings, an applicant has to explain the reasons for the delay and why, despite the delay, he claims he cannot be afforded substantial redress at the hearing in due course. I must also mention the fact that the applicant wants to have the matter resolved urgently does not render the matter urgent. If you cannot be afforded substantial redress, then the matter qualifies to be enrolled and read as an urgent application. If, however, despite the anxiety of an applicant, he can be afforded substantial redress in an application in due course, the application does not qualify to be enrolled. Now, apart from substantial redress in due course, your ladyship will ask, what is the significant date for that? And the significant date when the period starts to run is generously viewed the 13th of December 2017. Had injunctive relief been sought on that date, the applicant could well have been in court today or shortly after today in South African courts, and we imagine even more speedily in the English courts where there were pending proceedings. So we make this submission in paragraph 23. At no point has the applicant contended it will not enjoy substantial redress in due course. And I'll get to what my learned friend said on his feet this morning. This is squarely raised for the first time in heads of argument. Indeed, had it instituted proceedings in December 2017, it would have the matter heard in the ordinary course by the end of March 2018. And in paragraph 24, we make the point that this concession is in contradiction to the relief it pays for in terms of the notice of motion, namely it accepts that it will grant relief in this court and that the English proceedings were subsequently decided against it, it would have to return the aircraft to those parties. That is why the respondents do not pay for a permanent return of the aircraft, but rather a temporary arrangement, as they suggest, pending the outcome of the English proceedings. What is equally significant is that it could have obtained that relief by obtaining relief, including injunctive relief, in English courts when the matter is pending. And to round that off, we make the point in paragraph 25 that it's quite obvious the respondents' pursuance of the English proceedings is dispositive of the applicant's speculation that the aircraft may never be recoverable. The respondent's submission to jurisdiction and its continued maintenance and care of the aircraft demonstrates that it was performed in such a way as it ordinarily would have, and consequently any rights of the applicant would be pursued. Your ladyship put it bluntly, you maintain the aircraft because if you're using it, you're going to face the risk of injury or death if you don't. Now, this morning, our learned friend, in this so-called cascading sequence of events, added the Estina issue and the issue of the closure of the account by the Bank of Baroda. But in fact, he was mistaken on the date he gave to your ladyship. Those accounts were all closed at the end of July 2017, when that matter was widely publicized. There was then
the four banks. This is the four banks.
Bank of Baroda.
But was
Bank
that
of
account
Baroda.
closed July 2017?
The four banks ranged, I'm talking from memory, but it started in 2016. It started in 2016 with Nedbank, November or December 2016, and the matter was in court in April of last year, by which time all of the four major banks had terminated these bank accounts. All on the basis of reputational harm. So, your ladyship's question reminds me to make this submission. If you have the four major banks in South Africa saying that the Guptas should be unbanked because of reputational harm already at the latest, all of them.
Well, was it entirely reputational harm? I thought the banks. It was the Guptas were politically exposed individuals.
Some didn't give reasons, some put up the reason, the PEP reason, but that also is reputational.
Politically exposed persons, by PEP, yeah.
PEPs. So that's in relation to the four major banks. You didn't even have to wait for the Bank of Baroda to take action, which was the last bank standing, and it terminated those accounts in July 2017. There was litigation in August or September of 2017, and although interim relief was obtained, the point about the...
So you're saying Baroda terminated the Gupta accounts July 2017, and then the litigation followed, yes?
Litigation followed. I'll give you the exact date. It was in September 2017, round about the third week of September 2017. But that was litigation by...
When did the Bank of Baroda give notice of leaving?
Towards, I don't have an exact date, it was towards the end of July 2017. A little earlier. The Bank of Baroda gave several notices. The first notice was the 6th of July, and then they extended it for a few days, and I think it was finally extended to the end of July, not finally, end of July and then September. But the first notice, our learned friends remind me, was on the 6th of July 2017. So much so, even for the case our learned friend made on his feet this morning, Bank of Baroda has no comfort there in relation to bolstering their case. And when we get to the Estina order, for various reasons, we say that's even less.
When did the Reserve Bank announce that Bank of Baroda was leaving?
No, the exit from South Africa is February 2018. But that's the exit from South Africa in terms of the bank operating in South Africa. Before that, the bank had terminated all accounts of these Gupta entities in July. July 2016. Yes.
Both accounts were terminated in India as well, and Dubai.
I can't be sure of that, but I know all the South African accounts were
all the South African.
in July 2017. And then, just with reference again to our heads, in paragraph 27, we take your ladyship to the decision of National Police Services Union versus the National Negotiating Forum. And although in the context of a Labour court decision, this is what was said in terms of delay. The latitude extended to parties to dispense with the rules of this court in circumstances of urgency is an integral part of a balance that the rules attempts to strike between time limits that afford parties a considered opportunity, we highlight that, to place their respective cases before the court, and a recognition that in some instances the application of the prescribed time limits or any time limits might occasion injustice. And had they followed proper procedures and not brought this case on the urgency they had, for example, your ladyship wouldn't have been having the debate as to why the notice of strikeout was only delivered yesterday and hadn't been delivered before, and whether Mr. Bester should have been working 25 hours instead of 24, and all of those things. But the point is, the Labour Court said that this exception to the norm should not be available to parties who are dilatory to the point where their very inactivity is the cause of the harm on which they rely to seek relief in this court. For these reasons, I find the union has failed to satisfy the requirement. And we're not going to make your ladyship suffer with another reference to Luna Meerbils, which is in paragraph 28, but in paragraph 29, we would like to take you to the Golding HCI decision, where we say further urgency will in all likelihood be considered as self-created in circumstances where the applicant chose to not bring the application at the earliest opportunity, particularly where the applicant may have had prior knowledge which would have justified acting earlier. We say this was held in Golding versus HCI Managerial Services, with the reference to Prest, the portion that's in bold. A delay of 9 days may not appear to be lengthy, given the deploringly slow pace at which the wheels of justice often turn. But in circumstances where the applicant knew when the disciplinary hearing was due to commence and yet gave the respondents less than 1 court day before this application was to be heard, having taken 9 days to draft its own lengthy final papers, I agree with Mr. Pretorius that the urgency is self-created. Although the court is talking there about 1 day, the questions that were asked of the applicant go pertinently to this point. You could not have started drawing these papers on the day that you got the resolution. The resolution authorizing it is, I think, dated the day before the launch of the papers, dated the 14th of February. When did you start drawing these very lengthy and involved papers? And they never tell us that, but more importantly, they never tell your ladyship that. And you can't hide behind legal privilege, because all you're asking for is a date. When was an instruction given? Not asking for the content of the discussion, not asking for anything else. And had they truly had a proper explanation for that, and had they wished to take the court into their confidence, they would have told your ladyship that. But instead, we must be led to believe that a decision is taken on the 14th authorizing the matter, and on the 15th, Weber Wenzel, as efficient as they are, get out this complicated, hefty application, where all sorts of aspects are referred to, and the Cape Town Convention, and all of these agreements. So in rounding off our submissions on urgency in paragraph 30, we say, even if there was some merit in the applicant's contention that the matter is urgent, which we deny, the case authority is decidedly against it for an entirely different reason. It should not be permitted to subject the respondent to severe time pressure where it had prior knowledge of events and could have acted earlier to allow proper articulation of the dispute. Incidentally, this also speaks to why the applicant's avoidance of the respondent's questions raised in the answering affidavit must operate to their detriment. The information is material to determine whether in this context the case of urgency is fair, or we add self-created. If we can then turn to the issue of jurisdiction, and in the heads, if we can ask you to skip to section G, starting at paragraph 66. when you get
Wait a moment, I just want to start with, are you open to say? Debbie? What is it, paragraph?
paragraph 66, milady.
I presume everybody's okay with going over time, right? The stop copper, you have no say in this.
We don't have a problem.
Very well, thank you.
There are two questions when you get to jurisdiction, lady, two principal questions. And the one is whether they should be allowed to rely on the carve-out, and we'll get to that. The carve-out is essentially 27.4 of the lease agreement and the equivalent clause in the finance agreement. But the second is that even if they come within that carve-out, whether this court, on the basis of the principle and the doctrine of convenience and effectiveness, should exercise jurisdiction.
Now, is the doctrine of convenience part of South African
Depends
law?
which point you look at it from, convenience or non-convenience. It's the same issue. And we'll deal with
Despite what was said in that judgment
yes,
by...
we're going to deal with that.
Will you deal with that?
We're
Very
going to
well.
deal with the judgment.
Okay.
In paragraph 66, we say, the question of whether this court has the jurisdiction to entertain the application or whether it is the forum convenience to do so are closely related and will be answered together. We make out the point that the respondents do not submit to the jurisdiction of this court. We set out clause 27 of the lease agreement, and we're not hiding anything from your ladyship. Our learned friends said the portions that they don't like, didn't refer you to, we set it out fairly and squarely for your ladyship. It's to be found at pages 203 and 204 of the papers, but we've set it out at page 34. So firstly, clause 27.1 says the agreement in any contractual obligation...
Oh, sorry, where are you reading from? I beg your pardon? 203?
Our heads.
Oh, you're reading from your heads, sorry.
Paragraph 68.
Oh, sorry. Yes, that's 27.1, yes.
27.1. It's governed, the agreement's governed by and construed in accordance with the laws of England. Clause 27.2 says, subject to 27.4 repossession, and that is what we've called the carve-out, the courts of England and Wales shall have jurisdiction to settle any dispute arising out of in connection with the agreement, including a dispute in relation to the validity. And even if we can pause, even if your ladyship is applying a prima facie test, the question of validity is still in dispute in this matter. The parties agree that the courts of London, England are the most appropriate and convenient. Now, apart from what is said about for whose benefit the clause is, what your ladyship is told, that the parties both agree that the courts of England are the appropriate and convenient courts to deal with the issue. As such agreement confers jurisdiction, then the portion our learned friend referred to, and accordingly neither party will argue to the contract, it might be to the contrary, save that as such agreement conferring jurisdiction is for the benefit of the lessor only. The lessor shall retain the right to bring proceedings against the lessee in any other court. Now, if this was a dispute which started on a clean page and there had been nothing else, and the lessor decided that despite the agreement as to the jurisdiction of the English courts, the lessor wanted to proceed in South Africa, the lessor may have had that right because of the provision saying that it's for the lessor's benefit. But that is not the factual position. The factual position is that at the time these proceedings were launched, there were already pending proceedings in England, which Mr. Cook's clients had no choice but to proceed in the English courts. And the context of that, one has to then consider whether it's appropriate for this court to deal with it. So we don't approach this as if nothing has passed and there are no pending proceedings, and the lessor says, well, I could waive this clause because it's for my benefit and I'm proceeding in South Africa.
So despite the fact that this court would have jurisdiction?
Well, they could have elected to come to this court. because they could have waived, if there were other connecting factors with the court, and that would be a different debate, and there were other factors for jurisdiction, they could have waived going to the English courts and gone to any other country. But we say they cannot simply think away the fact that there are already pending proceedings in England. And then we get to clause 27.4, and that is...
So the applicants are Canadian, and Canadian, right? The one is EDC Canada.
Some are in Ireland and some
in,
are
yes.
in Canada. Respondent one, I think.
So you say that would have been the more convenient. The UK would have been the more convenient.
Indeed,
UK
and
and
it's
Wales.
also the court where we were obliged to go. Mr. Cook's clients were obliged to go to the English courts. But we get to the carve-out in 27.4, and that is the carve-out for repossession. And we make this point up front, that the first question on jurisdiction and whether they can rely on a carve-out is an interpretational question. And that interpretational question...
Sorry, so are you saying the carve-out is the agreement?
The carve-out is 27.4.
Yes, the court
which says,
shall have exclusive jurisdiction.
Notwithstanding the provisions of 27.1, governing law in 27.2 jurisdiction, the governing law and jurisdiction shall, in case of a repossession action by the lessor, in accordance with clause 24, deregistration, be at the exclusive choice of the lessor, any law and competent court in which jurisdiction the aircraft may be physically positioned. And they place reliance on that, or as we understand, they place reliance on that in the papers. That we say cannot be what they, on the one hand, want you to believe is a temporary repossession, because that clause must, read in its proper context and against the background and in the light of Indumeni, be interpreted to mean a final repossession.
Yes, so it's a repossession action.
Yes, indeed. That's the second point we make in our heads. It's in a repossession action, and that's final repossession. And those words are not just accidental, because in such an action, the dispute is fully ventilated with evidence and with witnesses and with expert evidence, the kind of debate your ladyship was having with Mr. Cook about whether the aircraft diminishes if it's not flown or it's not maintained. There's a reason why those words are put in there. So we say they don't come within the carve-out because this is not a repossession action. On the one hand, they want the benefit of saying it's interim relief and interim proceedings. On the other hand, they want the benefit of the carve-out, and they can't ride both stools. But we also say, apart from the point, there are 2 points in that clause your ladyship has picked up.
Yes, but sorry, 24.5, the latter portion which says, as such agreement conferring jurisdictions for the benefit of the lessor only, the lessor shall retain the right to bring proceedings against the lessee in any other court in another country.
Yes.
So
we dealt with the last portion of 27.2.
Yes.
Our submission in that regard is that if this was an action which they were starting de novo, and I say de novo in the context that there weren't pending proceedings, they might have been able to rely on that. But when you have regard to the fact that they're pending proceedings, it's not simply a question of saying we elect to go there and forget that this matter is going to be strenuously fought in the English proceedings, where the respondents have gone to court to say your basis of termination is a spurious one. You've tried to engineer a basis for termination where there isn't one. The submission on 27.4 then is a different one. There are 2 points. Firstly, it's the repossession action point, and secondly, we say, I'm sure there's a better description, but in the heads we call it a repossession in toto, or if you want to call it a final repossession, a permanent repossession if you want. And we then say, of course, we give you the references to the similar provision in the facility agreement, And we make the point in paragraph 70 of the heads, given that the repossession action in the current proceedings is linked directly to and can only flow from a valid termination, and that there are already pending proceedings in England with regard to the validity of the termination, and these courts are seized with the dispute, this court should decline to exercise jurisdiction. And in paragraph 72, we make the point on the plain reading of the terms of the various agreements. It's clear that our courts cannot interfere with any proposed application where it is subject to ongoing termination proceedings, which are solely reserved or carrying on in another jurisdiction and are pending in that jurisdiction. The repossession claim in this instance cannot be divorced from the pending English proceedings. And we say in 73, if the applicant's interpretation is correct, it would mean that they would be entitled as a matter of course to act in a way that could effectively amount to a repudiation of the obligations under the contract, but where the applicant would not be able to be held liable for its conduct. Because rather than take action to terminate, there's a typographical error, there's a 2 missing, take action to terminate the contract, and or defend same in England, they could simply take equivalent action to bypass the termination and simply act to repossess, as they've done here in another jurisdiction. The applicant's attack is effectively that it would be entitled to relief otherwise denied by the very contract whose terms it is purporting to rely upon. Termination and repossession are not alternative forms of relief. They've got to be pursued terminately. Because the right to repossession, my lady, it's an obvious point, but it needs to be made, is dependent, yes, and arises out of the right of termination and the act of a lawful termination. Then the numbering goes slightly wrong in paragraph 74 in the sub-numbers where we deal with the carve-out. We say furthermore, and although the applicants purport to act under the carve-out in clause 27.4, in that they seek to obtain relief in South Africa divorced from the validity of the termination of the lease, they are prevented from doing so for the following reasons. And wherever your ladyship has 69 as a sub-number, my lady, we ask that that be corrected to 74. So it's 74, 174, 274, 3. And in incorrectly numbered 69.1, it should be 74.1. The clause speaks of repossession action. Your ladyship has that point. We say an action proceeding must be used because in action proceedings there's a full protection of rights as in trial proceedings. There can be the calling of witnesses, expert witnesses, and the leading and testing of evidence. In 74.2, we say the clause anticipates a repossession, and perhaps just pause at that point, my lady. We wouldn't be, if this was a proper repossession action, you're talking about a prima facie test and whether you should accept their allegations of reputational damage, etc., etc. Their witnesses would be interrogated on that. They would have to meet a balance of probability standard in the matter. So these are not insignificant provisions in the sense of the kind of proceedings that I envisaged. And then in old 69.2, correctly 74.2, the clause anticipates repossession in toto, that is permanent repossession and not a temporary repossession in lieu of pending proceedings in another court. It's clear the clause is meant to operate as a means for final relief, and we say it makes no sense that the drastic relief envisaged by the clause would be, in practice, be qualified and temporary. And in 69.3, now 74.3, similarly, the deregistration of the aircraft is a permanent outcome. This too is drastic relief, apart from the fact that it will render the English proceedings moot, to the extent that once the aircraft is deregistered in South Africa, regardless of what the English courts decide regarding termination, the aircraft will be unusable because it cannot fly without proper certification. And this also has the consequence of demonstrating why the applicants are spuriously attempting to seek relief in South Africa as opposed to launching urgent injunction proceedings in England. Because once they obtain deregistration, they would effectively have forced the respondents out of the terms of the contract. The respondents would only be able to make good on the English proceedings victory after re-registration of the aircraft, which is not guaranteed, and particularly where the applicants may object to such process. The applicants are engaged in a subtle form of forum shopping. We say it's not that subtle once one scrutinizes it, and the courts should not permit that. We then deal with the forum non-convenience doctrine, and before I get to the agri-wire matter, we take your ladyship to the multi-links decision in paragraph 76, where Judge Fabricius, in the passage quoted, said the appropriate or natural forum is that which action has the most real and substantial connection in the context. Then the court would look at all the connecting factors, including background facts, convenience, experts, the law governing the relevant transactions that take place, etc. But it's useful to have regard to more than just the passage we quote in multi-links, because at paragraph 23 of that decision, it's at page 1175 of our bundle. Paragraph 23 set out the judge said it is in that context, it deals with the Strang decision, it is in that context that the question of forum convenience arose, and the question of whether there was sufficient links between the suit in this country to render litigation appropriate here rather than the report of the defendant's domicile. It is also in that context that the question of appropriateness and convenience arose, questions which had to be dealt with on a factual basis and developed case by case. And further down, he deals with the Spiliada decision and section 19(1) of the Supreme Court Act. And he says the appropriate or natural forum is that which the action has the most real and substantial connection. In that context, then the court would look to all the connecting factors. And here we say where there's a pending action where you say you're going to have a counterclaim, that the court to look at is the English court. Now, yes, and those factors we further elaborate on in paragraph 77. It's the English courts are seized with the dispute. We have been forced to go there. They've said they're going to institute a counterclaim there. Neither of the applicants are based in South Africa. One is registered in Ireland and the other in London. And we point out that it's because parties were from multiple jurisdictions, they obviously agreed on the English courts and English law. We then get to the agri-wire decision, and if we can make this point firstly, it was referred to by our learned friends this morning, and I think it's in their bundle. Find my agri-wire decision. I'm just looking for. Oh, Esther, can you give that one? Mr. Best is the culprit again, milady. He's stolen the applicant's bundle of authorities. It's a white file. Yes, it's in the applicant's bundle that I marked my copy. Gave you It's my junior, not Mr. Cook's junior, that's the culprit. It's at paragraph 1 of the bundle. Sorry, page 1. And the dicta that our learned friend referred to has an important proviso, but firstly, just to make some of these points. the Agri-Wire decision is not really useful because there what was in issue was the correct interpretation of the Competition Act, and from memory it was whether the tribunal had exclusive jurisdiction on an issue or whether you could go to the High Court. So the classic test when one litigates in South Africa on the issue of the ouster of the High Court's jurisdiction in cases going back to Seke, Boskop, Karasi, etc. was an issue there. And the issue was, although the tribunal had jurisdiction, did that exclude the High Court's jurisdiction? And the court found that the High Court's jurisdiction was not excluded. So it dealt with the interpretation of the Competition Act. The passage that our learned friends referred you to, I think, is paragraph 19 of the judgment. Where the arguments were summarized, and then the court said, in that context, that on the question as to whether the court should have exercised its jurisdiction to decline, to grant relief, and to have left it to the tribunal, the court said that is a different matter from the court declining to exercise the jurisdiction with which it is vested by law. And then the statement, which we say is out of context, you say in admiralty matters, our courts does not recognize the doctrine of forum non-convenience, and our courts are not entitled to decline to hear cases. But even taking that dictum, this is the important part, to hear cases properly brought before them in the exercise of their jurisdiction. And that was the whole point. The case there had been properly brought before the High Court. And the court said, once a case is properly brought before us, we will not say that the tribunal has exclusive jurisdiction and you should go to the tribunal on that score. And we make the following point also. We say the reliance on Agri-Wire as being a prohibition against the reliance on forum non-convenience, we say only applies where those matters are properly before the court to which the challenge to jurisdiction is made. In that case, the High Court. We say the matter is not properly before this court. So even on that basis, one can disregard the dictum. But furthermore, that case, the doctrine has found as a general proposition application in a number of cases.
But what is the aspect that makes it not? Why is not properly?
For the reasons, for all of the reasons that we took you to earlier, on not coming within the carve-out, on the proper interpretation of the carve-out, etc., etc. And your ladyship can have regards to the Metlika decision, where we say our learned friends' reliance on Metlika on this leg of the argument is misplaced. We say Metlika did not concern multi-jurisdictions as regards the registration of the aircraft and the submission to jurisdiction. And in the SCA, in another decision, Zongi, Z-H-O-N-G-J-I, Zongi, Development Construction Engineering Limited versus Komoto Copper Company.
That's Komoto.
Komoto.
Yeah.
KMOT of 2015 Volume 1 SA Law Reports, page 345. The Supreme Court there distinguished Matlika where there was a valid agreement between the parties that would determine the jurisdiction of the tribunal and would be capable of rendering the most effective relief. And the courts there respected the choice of jurisdiction. Distinguished Matlika when there was a valid agreement between the parties that would determine that went to jurisdiction. And where that tribunal, it was in the context of an arbitration agreement, that the same principle applies, and where that body would grant the most effective relief. Then, milady, we come to the famous Stina order. Firstly, all of the points made.
Sorry, are you suggesting that this court can't grant relief?
Yes, we say that the aircraft isn't here, you've got to try and go and execute this, and they tried to craft some kind of relief here. But we say effectively the aircraft is not here, and the dispute on the validity is currently being fought in the English courts. Validity of termination. Getting then to the Stina application and the preservation order there, even before the decision of this morning, all the points that were made in the heads remain. Firstly, that was an ex parte application where there were untested allegations. An order was obtained ex parte, which was not tested. Significantly,
But that's not suicide.
well, the relief insofar as it concerns any of these applicants has been set aside. In essence, if I can summarize it, and I'm going to give you in our learned friends copies of the photograph of the order as we received it at about lunchtime, milady.
And I had a journalist, she's probably dead. Was prepared to photostat your application. Not photostat, copy of it.
My resourceful junior has come up with a typed copy of the order, so you don't have to rely on the photograph, but he tells me he's not sure if it's not sufficient, but we've got one for the applicants and one for you, and we'll let Mr. Cook work off the photograph. Without belaboring the point, firstly, your ladyship, to make sense of what was done, I'm going to give you the submission. The submission is that against all of the entities involved in this matter that the applicants rely on in relation to the order being made, the order was set aside against all of these entities. Against some of the other entities, the order was not set aside because
Sorry, so you said all of the respondents?
All of the respondents here.
And including Ms. Raghavan.
She's not a respondent.
No, she's not a respondent, but she's part of the.
Yes.
She's deposed to the affidavits.
I look at the order in relation to her. I looked at it in relation to the respondents.
Yes.
But in relation to certain parties that were not applicants, the order was not set aside, and other parties, the order was varied.
But in relation to all the respondents here, the order was set aside.
The order was set aside. And to make sense of it, your ladyship will have to read this with the 18 January order, which is an annexure to the final papers at page 328, I believe.
What date is it? The January 13th.
328. Can you just check that? Is that correct? FA 19.
Sorry, it's FA 19. Sorry, I just read page 328. Sorry, I think it's there. That one. I'm going to close that one.
done the exercise, and perhaps Julia can just check as I go along. Paragraphs that are material to us that were amended is firstly in relation to the to paragraph 12 of the order. Starts at 330. The portion I want to take you to will be 331. The order against Mr. Atul Kumar Gupta, paragraph 12.3, was deleted. And that appears, my lady, if you want to follow it from paragraph 4 of today's order that I've handed up to your ladyship.
Oh.
Paragraph 4 of today's order, which is marked 9 March,
Yes.
is
So,
what I rely on for to show you the deletion of paragraph 12.3
oh, yes.
against my client, Mr. Atul Kumar Gupta, respondent 3. Then against Oak Bay Investments, respondent 2, paragraph 12.5 of the order is set aside. And then against Westdawn, respondent 1, paragraph 12.13 of the order was set aside. And the order, of course, also referred to these parties in Annexure A of the order, which went to the bank accounts and the payments. And with reference to paragraph 5 of today's order, the 9 March order, if your ladyship goes to Annexure A at page 334,
234.
334, in the same annexure your ladyship is in. Having regard to paragraph 5 of today's order and read with page 334, 1.4 of Annexure A against Mr. Atul Gupta for the 10 million was set aside. Paragraph 1.9, the order against Oak Bay Investments for 24,500,000 was set aside. And paragraph 1.12, the order against Westdawn for 6 million was set aside. So, Your Ladyship, all these cascading events that we're told about, notwithstanding the hearsay and untested nature of these allegations, they are forced just to make the point. It shows why it's so reckless to rely on untested allegations in coming to court, because once this matter was argued before the court and the court's attention was drawn to facts in the NDPP's own founding papers, this is what the result of that was. But, my lady, there's a further answer that even before one got to the order, in our view, the reliance on these so-called improper payments was entirely misplaced. And I say that and want to take your ladyship to page 197 of the papers.
One.
197.
Oh, sorry. Thank you.
And our learned friend read some of the clause to you, but we,
Oh, sorry. Debbie, it's the other one.
it would be 22.1 R.
It should be file 2.
It's part of FA4, the lease agreement.
197. Sorry, 197. Yes, R. Is it R? No, is it R? Yes.
Yes, it's R.
Yes.
And fairly read, what it means is not only well, let me read the clause and then make 2 points to you. No prohibited payment has been made or provided directly or indirectly. Now, if one pauses there, that's got to be the fact of a payment, not an allegation, not an accusation by somebody, an actual fact of a payment. And then it goes on to provide by or on behalf of or to the lessee or any of his respective affiliates, subsidiaries, etc., etc. And then, and no officer, director, or lessee or any other person acting on the lessee's behalf has been held by the judgment of a court in a criminal or civil matter to have made or received the prohibited payment. So we say this was just a red herring, my lady. There's never been, and we made the point in the papers and we made the point in the heads, there has never been a finding in a judgment of the court in a criminal or civil matter finding that these persons received these payments. And that's even before you got to the setting aside of essentially a preservation order. Your Ladyship, we say then your Ladyship should strike the matter from the roll with costs of to counsel in relation to the third and fourth respondent, and alternatively, to the extent that your Ladyship is going to deal with the merits, you should dismiss the application with the costs of to counsel. If your Ladyship would bear with me for a moment. As it pleases the court, my lady.
Thank you. Thank you. You have the graveyard shift.
Thank you, Baroda. Lady, it is the graveyard shift,
Yes.
and I hope to be as short as possible. It's been a long
Please.
day for all of us. and
We'd all welcome that.
I'm going to thank you at the end of the day for sitting such lengthy hours, but may I try and make the Ladyship's task a little bit easier
Very well.
by trying to do as quickly as I can. I'm going to try and deal with the submissions by my learned friends thematically today. In other words, I'm going to try and group them together under headings rather than dealing separately with what was said by our learned friend Mr. Cook and our learned friend Mr. Barnett. May I start with jurisdiction, which was only addressed by our learned friend Mr. Barnett. And I can be extremely quick here because what he said with respect is simply wrong in law. Let me start with his first submission. He said we can't come home under the carve-out in paragraph, in clause 27.4 of the lease agreement. Lady, can I ask her Ladyship to go to what our learned friend calls the carve-out? She'll find it in the lease agreement. It's clause 27, and she'll find that as an annexure to our filing affidavit, commencing on page 203.
I think it's the other file. It's the file 1. No, 203. Oh, it's that one. Okay, thank you. Yes, it's right. Yes, I'm at the page, Mr.
It is page 203, halfway down, law and dispute, a clause her Ladyship will not be familiar with.
Yes.
Our learned friend takes the court to 27.4, and he spent a huge amount of time explaining why we can't come home under 27.4, the carve-out. But lady, with respect, I don't have to come home under 27.4. I say I come home under 27.2, and that was the submission I made to you this morning.
Yes.
So with respect, I don't have to engage with my learned friend's argument because 27.2 is the one which says it's the election of my client, Stone River, in which court it wants to proceed. Now the only response of our learned friend Mr. Barnett to that was to say, but no, 27.2, that right can't apply where there are other proceedings pending in another court. But then it doesn't say that. I'm going to read the words to you again at the bottom of page 203. It says, save that, as such agreement conferring jurisdiction is for the benefit of the lessor only at Stone River, the lessor shall retain the right to bring proceedings against the lessee in any court in another country. Not as long as there are no pending proceedings, it's an unqualified right. And milady, the unqualified nature of that right is made particularly clear in the...
So must I look at the plain language of the clause?
It's as obvious as that, milady. One looks at the plain language and one can take out that page, one can hold it up to the light, one can stand on one's head But it's not going to say, unless there are pending proceedings in another court. It simply says you have the election. And the facility agreement puts that beyond all doubt. It uses words which make that clear. If I can ask her ladyship to go to, it's now an annexure to the answering affidavit.
So you say there's no qualifier?
It's not qualified.
Yeah.
It says it's an unqualified right to my client. You decide which court you want to proceed in. It's not hemmed in by any restriction regarding whether there are pending proceedings. It simply says you have that right. So, with respect to her ladyship is entirely correct. It's just the plain meaning of the clause, and it doesn't permit of any doubt. But if the lady wants further comfort, she can go to the facility agreement, which is page 697. It's an annexure to the answering agreement, to the answering affidavit.
Yes, it's just, I've seen it, so just.
And let me
yes,
read it to her
very well.
ladyship. For record purposes, it's clause 37.1.c. It says this clause is for the benefit of the finance parties only, that's EDC. As a result, no finance party shall be prevented from taking proceedings relating to a dispute in any other court with jurisdictions. Very similar to the lease agreement, my lady. But then it adds these words. To the extent allowed by law, the finance parties may take concurrent proceedings in any number of jurisdictions. So the facility agreement expressly contemplates that my clients can go in England in one set of proceedings, in Venezuela, or in South Africa, or in Ireland in another set of proceedings. And there is just no getting away from the words with respect. So my learned friend's attempt to build...
But even if they're related proceedings?
No,
Yes, I'm saying, I mean, you're saying it's unqualified, your client could go...
completely unqualified.
Yes.
It's as simple as that. Lady, my learned friend's other submission regarding jurisdiction was about the doctrine of forum non-conveniens. And he made, with respect, an extraordinary submission. He says this court is not bound by AgriWire because it was dealing with another issue. I'm going to ask the court to go to AgriWire to show how astonishing that submission is. I'm going to ask the court to go in our bundle of authorities to paginated page 9. If I can ask the court to read the relevant passage again. It's at the top of that page,
Yes.
the fourth line from the top. This is the Supreme Court of Appeal. Save in admiralty matters. No one suggests this is an admiralty matter, lady. Our law does not recognize the doctrine of forum non-conveniens, and our courts are not entitled to decline to hear cases properly brought before them in the exercise of their jurisdiction. Now there's the problem for our learned friend. How do they try and wriggle out of those words? The first submission is they say, this was a dictum limited to competition proceedings. But, my lady, go to the footnote. Her ladyship will see footnote 9 at the end of that sentence. And if her ladyship goes to page 11 of our bundle,
Yes.
the ladyship will find the authorities relied on by the SCA. And not one of those is a competition case. So I've looked at all of those judgments, my lady. All of them are dealing in a non-competition context. With whether a court...
Is that footnote 9, right?
That's footnote 9.
Okay.
Those are the judgments the SCA relies on for the proposition, and they are not competition cases. One dealt with a situation where a plaintiff sues in the High Court, and he or she could have sued in the Magistrates Court. High Court says, I can't decline to exercise jurisdiction. So the principle in AgriWire is a broad principle, not a narrow principle about competition law. It says, if you have jurisdiction, High Court, you can't say, I would prefer not to exercise jurisdiction. That is the principle, and no amount of wriggling is going to avoid the strictures of that principle for our learned friends. But our learned friends
The point that Mr. Mvana made about it has to be a proper, sorry, I beg your pardon, what is that?
Ladyship is quite right. That
Properly
was
brought. It has to be properly brought before them.
properly brought before them in the exercise of their jurisdiction. But this was properly brought before this court in the exercise of its jurisdiction. All 4 respondents are in coli. The Ladyship has not heard a word to dispute that. 2 of them live in Saxonwold, the others have registered addresses within the jurisdiction of this court. So to suggest that it was not properly brought before this court simply is unfounded. At best, it's a circular argument. They say, we would like to have a doctrine of forum non-convenience, and therefore it was not properly brought because this is not the convenient court. But of course, that's a perfect circular reasoning. The case was properly brought. No one disputes the court has jurisdiction. And this court, in the light of Agriwire, cannot say, I would prefer not to exercise jurisdiction. We should rather go to the courts of England. Then our learned friend's last submission on jurisdiction was about the SCA judgment in Metlika. Lady, it's been a long day. I'm not going to take her ladyship to that. We deal with it in our heads.
Very well, just tell me where.
But with respect, the facts are almost fully the same as these facts. In that case, my lady, it was a predecessor of the Guptas. The person in that case was Dave King. The ladyship may
Infamous
recall.
Dave King, yeah.
Dave King also had an aeroplane. That aeroplane was taken outside the jurisdiction of this country. And one of the issues in that case was, could the court give an order compelling the respondents to return the plane to South Africa? And the point taken in that case was, no, you can't, because your order won't be effective. The very proposition our learned friend Mr. Barner relies on. But the SCA closed that down. They said, of course the order's effective. It applies against Incoli of this division, and if they don't comply, they will be committed for contempt of court. And milady, our relief is modelled on Metlika. We've done something very similar. We've done it in exactly the same way. We ask you to give an order against Incoli. If they don't comply, they will be committed for contempt. That renders the order effective. And with respect, that is the end of the debate about Metlika. Metlika closes down that debate. May I then proceed to the merits? And I can be extremely brief here because Her Ladyship only heard 2 submissions on the merits, on the prima facie right. So in the course of a long day of argument, when Her Ladyship asked herself, what did she hear about the prima facie right from the respondent, she heard only 2 things. It took up perhaps 10 minutes of the argument. The first thing she heard is this. She heard from our learned friend Mr. Cook that he hands up these 2 English cases and he says, aha, but those cases say where there's a long-term contract, if you want to terminate the contract, it must be some sort of material breach, not a trivial one. But lady, I took Her Ladyship to the lease agreement, and I'm going to read the words to Her Ladyship again.
Yes, you don't have to.
The lease agreement says any single event of default is an act of repudiation. It doesn't import any requirement of materiality, save in those cases where the shopping list imports materiality. I'll simply give Her Ladyship the reference for record purposes.
Yes, that would be helpful.
It's page 192. It's the lease agreement, and it's the wording right at the end of clause 2.1. Lessee, that's the Guptas, hereby acknowledge that the occurrence of any one of the foregoing events of default represents repudiation of this agreement by the lessee. Her Ladyship says, well, isn't it just a matter of plain language? Of course it is. It doesn't import any requirement of materiality. And so the English cases discovered by our learned friend Mr. Bester in the early hours of the morning are, with respect, no assistance to him. And what's the second submission this court heard on the merits? Well, this one came from our learned friend Mr. Barner. And he ran a new submission, not anticipated in the papers, not anticipated in his heads of argument. The first time we heard it was when he was on his feet. And what he says is, no, the relief we ask for is final in effect. It's not interim. And so we have to jump over the higher bar, clear right, not the lower bar, prima facie right. So he says the higher bar applies, not the lower bar. Why? Because although our relief looks interim, it's actually final. And why is it final? Her ladyship will ask. Well, our learned friend says it's final because it will never be revisited by this court. Because it will apply pending proceedings in the English courts, not pending an action or a final application in this court. Lady, with respect, that is a submission that is wrong in law, and it's wrong for several reasons. Let me give you the first one. The cases our learned friend relies on, all of them, are dealing with appealability, as he very fairly conceded.
Yes, what is that? The case of Justice Nugent. Is it Pirelli or Patelli or whatever, yeah.
It's dealing with whether the order is appealable, not dealing with the different issue of what bar you have to jump over when you are applying before the court, I quote, for relief.
Whether it's appealable or whether you rescind it. Yes, that's the point.
With respect, that's correct, my lady. So the cases are simply not in point. But here's the second reason. If our learned friends were correct, it would never be possible to obtain an interim order in this court pending the decision of an administrative body, or pending the decision of an arbitrator, or pending the decision of a foreign court. And that is not our law, my lady. Courts regularly give interim interdicts pending those events. My lady, the leading case on administrative reviews is one which we don't refer to in our heads. It's a well-known case of Air Road Express. May I simply give her ladyship the citation? It's Air Road Express, 1986, volume 2 of the South African Law Reports, page 663. It's a judgment of the Appellate Division. And the Appellate Division there grappled with this very issue, that the applicant wanted interim relief pending the decision of an administrative body. It was the local road transport appeal board, as I recall. And the issue was, can an applicant get interim relief pending the decision of an administrative body? And the majority of the court held yes. If our learned friends were right, the majority should have held no, because on our learned friends' reasoning, that would be a final order. It will never be revisited by the High Court, pending the decision of the administrator. And that's exactly what Air Road Express didn't hold. Lady, another judgment which is not referred to in our heads, but this is one where interim relief was granted pending the decision of a court in a foreign jurisdiction, is Lagoon Beach Hotel. Lagoon Beach Hotel versus Lehane, L-E-H-A-N-E. And the reference is 2016, volume 3 of the South African Law Reports.
Sorry, say that,
2016, volume 3, South African Law Reports, page 143. It's a judgment of the Supreme Court of Appeal. Lady, I've read it very quickly while my learned friend was arguing, but on my reading of the case, the interim relief was granted in that case pending the decision of an Irish court. And the FCA said it would be competent for the High Court in this country to revisit the order in the case of inconvenience or injustice pending the decision of the Irish court. And with respect, that would also apply here. Any order this court grants would be interim. If events were to change, it would be competent for the Gupta respondents to ask this court to reconsider it. Lady, our learned friend then said, under that heading, he said, well, go to the wording of the notice of motion. It shows the relief is final, not interim. But lady, it shows the exact opposite. It was clearly drafted to apply pending the decision, the final determination of the English proceedings. With respect, that is an interim order. It's as interim as the order in Lagoon Beach or as the order in Air Road Express. And so the suggestion by our learned friends that we must jump over the higher bar is simply wrong in law. But may I then deal with the strikeout application, and I can be brief here because it was argued only by our learned friend, Mr. Bester, and only in the context of our replying affidavit, which relies on the new event of default.
Yes, it wasn't, yes. So I presume there's nothing that is to be struck out from the answering papers anymore, from the founding papers anymore.
We understood our learned friends not to persist with that point. It's correct they didn't abandon it. I don't for a minute say they did, but you heard nothing from our learned friend, Mr. Bester, save to say that our learned friend, Mr. Barner, would address you on the poker order. So all I need to deal with is the new case made out in reply, and her ladyship now knows the sequence. After the founding papers were compiled and after the application was launched on 15 February, a new notice of default is issued. And the replying affidavit puts up the new notice of default. It's correct. It wasn't in the founding papers, but it couldn't have been in the founding papers because it didn't exist at the time. And Milady, we would ask the court to go to our heads of argument, to a judgment which we refer to, and we quote the relevant dictum, so perhaps it's easiest to go there. It's the judgment of Tantush.
Oh, that's Justice Murphy.
That's correct, Milady. Milady, we quote the dictum fully. It's on page 24 of our heads.
That's the point about pleading over.
Not entirely, Milady.
Yes.
His lordship was making a slightly different point.
Okay.
Saying, in fact, let me show you what his lordship held. It's page 24 of our heads, footnote 67. And this is what his lordship held. I'm going to read the dictums to her ladyship. As these averments were made in the replying affidavit, the second respondent, strictly speaking, had no entitlement to respond to them, and in the normal course they could not be denied or explained by the respondents. Nevertheless, if the allegations by Miss Peer were untrue, or if an adequate explanation were possible, leave of the court could and should have been sought to answer them. The respondents did not request to be given an opportunity to deal with these averments. Their failure to do so tilts the probabilities towards the applicant's version. So the new point is made in reply. The respondents had no right to deal with it, but his lordship says, if you had something to say, I would have expected you to say it. And may I add to that another judgment of the SCA, not referred to in our heads, but it says something very similar. It's PPC versus Competition Commission. PPC versus Competition Commission 2003, Volume 2 of the South African Law Reports, 385. Judgment of the SCA, the relevant paragraph is 63. Very similar to the Tantush dictum. In this case, something had been said in the replying affidavit, and in this case, the SCA held, now it's true that Mr. Simelani, who was the Competition Commissioner, had no right or duty to answer this allegation made in reply, but I would have expected him to offer to do so if the imputation of dishonesty were false. Very similar. You had no right or duty to deal with it, but if you had something to say, I would have expected you to do so. Now, why is that relevant to our case? My client files its replying affidavit in an urgent application. It refers to a series of events that happened after the founding papers were drafted. One of them is the February notice of default. It includes that under a heading. It says these are events that occurred after the application was launched. And one of them is the February notice. With respect, if the respondents had something to say, one would have expected them to say it. And yet, 8 days later, you have heard nothing from them. And on the notice of default, it would have been very easy to answer if they had something to say. Instead, what they've done is they've played, with respect, ducks and drakes with this court. They've refused to give an answer. They then applied for a strikeout yesterday, and now they say, well, if you don't allow the strikeout, they want a further opportunity to deal with it. With respect, that is playing games with the processes of this court, and they shouldn't be allowed to do so. Look, related to the strikeout application, may I then deal with the poker judgment, the one that was apparently set aside this morning by, at least in part, by the Free State High Court. And this is the submission made by the Mr. Barner. Let me start with this. We relied on the poker proceedings for two reasons. The one is to make out the prima facie right. The other was as being relevant to urgency, which I'll come to. When it comes to urgency, the fact that the poker order has been set aside has no impact on whether my client did or didn't have a justified claim for urgency. In other words, if my client was justified in launching on the basis of the poker application, I'll come to that in due course, it can't now retrospectively not be justified because it was set aside this morning.
You're saying it was justified at the time?
The claim was either good or bad. It can't retrospectively be rendered illegitimate if it were legitimate. That's the first point.
But as a default event, would that fall away? No?
Sorry, Melody, I couldn't
As a event of default?
Yes.
Yes.
No, with respect to that was
Yes,
the
for
second
purpose
point.
of urgency, it was relied upon at the time, and
That's
that
the
is
second point I
yes.
wanted to make.
Yes.
Lady, when I addressed argument to her ladyship on this event of default this morning, I was quite careful to draw this distinction. I said in relation to the commencement of the proceedings in the ESCOM case, it was the fact of commencement that was relevant. But when it came to the poker judgment, I didn't rely on the judgment itself, on the order. And why did I not do so? Because our learned friends point out in their heads quite correctly that the poker judgment was in fact handed down 2 days after the application was launched by my client.
Oh, yes, okay.
So my client launches on the 15th. I may have the date slightly wrong, but as I recall, the poker judgment was handed down shortly thereafter. So why do we rely on the poker proceedings? We relied on it in order to say allegations were made by the NDPP in the poker application, and those allegations were about what we would call prohibited payments. And we relied on that, and we said, we quote what the NDPP said, and we call on you to answer that, because we draw the inference that the payments you've been making are prohibited payments. In other words, you've received a prohibited payment, let me put it more precisely. Now, milady, that point is not rendered, it's not rendered illegitimate by the fact that the ex parte order of the High Court has now been set aside. Because our reliance was not on the order, our reliance was on the content of the founding papers. And we put up those papers, and as you heard me submit this morning, we simply had no response from the Gupta respondents. So they didn't answer those allegations. They still haven't answered them in our proceedings. And the fact that the High Court set aside the ex parte order doesn't allow them to say there is no basis for us to conclude that they were receiving prohibited payments. It's the content of the application that we relied on rather than the order itself. Lady, may I correct the sequencing? I got the dates wrong and I wouldn't want to mislead the court. I'm told that the correct sequencing is the repayment date, in other words, the date on which the warranty was made was 16th January, and the poker judgment was given on the 18th of January. So I apologize, I got the sequencing of it wrong.
16 January, and yes.
16 Jan, the repayment date, 18 Jan, the poker judgment. But the principle still applies, Melody. The point is, on the repayment date of 16 Jan, there couldn't have been a warranty to do with the poker judgment. It was only handed down 2 days later.
Yes.
The warranty we relied on was the warranty about not being a recipient of prohibited payments. And that point is not disposed of by the setting aside of the order this morning. And Milady, that then leads into a further submission made by Lindgren and Mr. Barner. He says, well, it's true that you try to rely on the poker proceedings for that purpose. But he says, you can't because the relevant warranty doesn't help you. Then, again, with respect, it is an extraordinary submission, and I'm going to ask her ladyship to go to the wording of the clause just to see how extraordinary it is. Her ladyship will find this on page 197 of the papers. It's the lease agreement.
It's the other one. Yeah, I've got it. Just take this one away.
Lady, it's clause R, which I took a ladyship to this morning,
Yes.
but let me read it again. So on the repayment date, which was 16 Jan, this is the warranty that is given by Westdawn. It says, no prohibited payment has been made or provided, directly or indirectly, by or on behalf of or to the lessee, that's Westdawn, or any of its subsidiaries. Let me leave out the
Sorry, I'm looking at the wrong
words.
file. Sorry, I think I'm looking at something else.
Sorry, my lady, it's page 197.
Sorry, 197 is the clause, right? No prohibited payment. Yes, okay, go ahead.
It's clause R.
Yes, yes, I'm with you. Sorry.
This is what it says. No
Yeah.
prohibited payment has been made or provided by or to Westdawn or any of its affiliates or any of their officers, comma, and no officer or director of Westdawn or any other person has been held by the judgment of a court to have made or received a prohibited payment. Well, lady, it would be pointless to say that those two requirements are cumulative, because what would be the point of the first part of the warranty? If the warranty was saying nobody has been held by a judgment who have received a prohibited payment, what would be the point of warranting that no prohibited payment has been received? So we rely on the first part of the warranty. No prohibited payment has been made to Westdawn or any of its affiliates. And with respect, that warranty is the one we rely on. It doesn't help my learned friend to say, but there was no judgment of the court, because the part of the warranty dealing with the judgment is severable from the part of the warranty dealing with whether or not a prohibited payment was received, in this case by Westdawn or Oak Bay. And then finally, lady, may I deal with urgency, which
Yes.
seemed to occupy a huge amount of time. And let me start, if I may, with the submission. I'm going to
Well, there's the
be
point that you don't make out a case that you can't obtain substantial redress in due course.
Let me deal with that for lady.
And I know you deal with the whole irreparable harm point, which...
Lady, Rule 612 says
Yes.
you must explain why you wouldn't obtain substantial redress in due course. And it would have been possible just to copy out those words, and then perhaps my learned friend would have been satisfied. But it would have been no more than a formulaic recital of what the rule requires. The ladyship will not find that formulaic recital in our finding affidavit.
Yes.
We accept that. But with respect, you can't just read the part of the affidavit under the heading urgency. You read that with the earlier part of the affidavit. Our learned friends are correct. The test for irreparable harm for interim relief is not the same as substantial redress. They're entirely correct. We don't dispute that. But what we do say is that when my client now turns to urgency, having addressed harm, this is what the affidavit is saying on a fair reading, the lady. It's saying, I cannot obtain substantial redress in the ordinary course because by the time I'm heard in the ordinary course, I would have suffered the various events I've referred to, the depreciation, the damage, the reputational harm, the prospect of forfeiture. And so on a fair reading, one has to read that part of the affidavit together with the earlier part. And the case made out is the harm I would have suffered by the time the matter is heard in the ordinary course is such that I would not obtain substantial redress. The lady has pointed out to me, when our affidavit turns in paragraph 128 under the heading urgency, that's the heading our learned friends fixate on. There's the heading urgency, and then the paragraph begins. The urgency of this application is manifest for the reasons traversed in the rest of this affidavit. So what the deponent was saying, with respect fairly, is I'm not going to recite everything I've already said, but at the end of the narrative I've given you, it should be obvious what the urgency is, and the deponent then tries to join together some of the dots. But with respect to take my client's affidavit, to go to urgency and say you did not formulaically recite the language of Rule 612 is not a proper way to approach these things. Lady, our learned friend, Mr. Cook, says when it comes to urgency, the Cape Town Convention doesn't assist us. But with respect, he's wrong, and I need to show her ladyship why that's wrong. And why
I think
the
he relied on, was it clause 14, 13?
That's exactly right. May I ask her ladyship to look at it, because I didn't do the exercise this morning, although the detail is in our heads of argument.
Yes.
But if I can ask the ladyship to go to the Cape Town Convention, I'll indicate why with
in your
respect to our
authorities- in
learned friend,
the
that
authorities.
submission is not a good one. It's our bundle of authorities. The ladyship will find the Cape Town Convention right at the back. I would ask her ladyship to go to page 475. Ladyship goes to Article 13, relief pending final determination. It's dealing with this sort of situation, my lady. It's where there's an aircraft which can be quickly and speedily moved from one jurisdiction to the other. And it says the contracting state, that's South Africa in our case, shall ensure that a creditor who adduces evidence of default by the debtor, that's Westorm, may, pending final determination of its claim, and to the extent that the debtor has at any time so agreed, obtain from a court speedy relief in the form of such one or more of the following orders as the creditor requests. And the lady A to C really does replicate at least part of our notice of motion. So the obligation on the state party is to give speedy relief in this sort of situation. If I can just stop there, my lady, our learned friend says, well, go one clause down, go to Article 14. And he says it provides any remedy provided by this chapter shall be exercised in conformity with the procedure prescribed by the law of the place where the remedy is to be exercised. So he says the convention does no work because it's all regulated by the law of the jurisdiction. But of course that's the law of this, it's the procedural law.
Oh, okay.
It means when you decide which court to go to,
the procedure prescribed by the law of the
you
place.
comply with the procedure of that jurisdiction. You can't go to a magistrate's court, for example, and say the convention allows me to ask you for speedy relief. So the procedure determines which court you go to and what procedure you follow. It doesn't determine what the speediness involves. In other words, how speedy must the relief be? What does determine that, my lady? What does determine how speedy the relief must be? That, her ladyship will find a few pages on at page 503 of the authorities bundle. And to ask her ladyship to go to it since it's so important.
Yes, yes.
So it's page 503. And just to orientate her ladyship, this is the protocol to the Cape Town Convention. In other words, lady, it's the adjunct document, if I can put it that way, that was concluded at the same time.
So
as
503.
503. And this is the part of...
This is chapter 2. Sorry, this is what?
This is the protocol.
Yeah.
And you will find it commencing on page 4. On page 497, it commences. So it's the protocol to the Cape Town Convention. And I would simply ask her ladyship to go to Article 10 of the protocol on page 503.
Mm-hmm.
Because this is what her ladyship will find.
Yes, sorry.
If her ladyship goes to Article X, that's Article 10, sub-paragraph 2, sub-article 2.
So Article 10.
And 2/3 of the way down the page. Article 10, modification of provisions regarding relief pending final determination.
Yes, Article 10 in Roman numerals, yes.
And then if her ladyship can go to sub-article 2, for the purposes of Article 1 of the Convention, lady, that's the article I've just taken her ladyship
Speedy
to.
in the context.
Speedy in the context of obtaining relief means within such number of working days from the date of filing of the application for relief as is specified in a declaration made by the contracting state in which the application is made. So speedy is a vague term. The protocol says, what is speedy? That depends on the obligation you undertake. And what was the obligation of South Africa? The ladyship will find that on page 537 of the authorities bundle.
Was that 10 days?
That's the 10 days, my lady. That's the 10 calendar days. So South Africa says, I'm not going to live with speedy. I will tell you what speedy is. And in our case, it's 10 calendar days. In another case of interim relief, it's 30 calendar days. But in our case, it's 10 calendar days. So, lady, with respect, when our learned friend, Mr. Cook, says, well, none of this matters because this court determines whether a case is or isn't urgent. With respect, that's not correct because the convention imposes these obligations on South Africa. South Africa firmed up that obligation in the protocol and in the 10-day undertaking. And that is relevant to the relief this court must give. If our learned friends are right, it will be struck from the roll My client will have to re-enroll the matter and will be heard in 3 months' time. Well, that is not speedy relief within the meaning of the convention or the protocol. Very quickly, some related submissions on urgency. We heard from our learned friend, Mr. Cook. He says he's not an expert on these things, but as
Well, urgency has to be dealt with in the context of the matter, am I right?
urgency is dealt with in the context of the matter. The Cape Town Convention is created for these very matters, precisely because aircraft can move and can move quickly. And the parties, including South Africa, assume the obligation to give speedy relief. And the submission we make is if the matter were to be struck, there would be no speedy relief. My client would get relief well outside of the 10 days, well outside of the 30 days. Very quickly on urgency, our learned friend Mr. Cook says, well, if you put an aircraft in a hangar, it appreciates in value. If you fly it, it doesn't appreciate. That is not on the papers. It's entirely counterintuitive. And that would be a matter for expert evidence. And there is simply no evidence on the papers to show that.
Sorry, I thought, was that not on the papers or was it in the heads of argument?
It's in the heads of argument.
It's in the heads of argument.
It's in the papers in the sense of the heads, but it's not on affidavit. It's simply something that our learned friends have, I say made up, I don't mean that in an improper way or an irresponsible way, but they make it a factual proposition with no grounding in the evidence. What our notice of motion says is if the relief were to be granted, we will maintain the aircraft. So the idea that it will rust or fall into disrepair in a hangar is entirely unmerited. That's exactly what the notice of motion contemplates will not happen. We will do the maintaining. I said that allegation is not in the papers. The closest we can come to is in the answering affidavit, paragraph 103, where they don't deal with this at all. So it's the answering affidavit, paragraph 103. It simply doesn't deal with the facts that you now hear from the bar. And then finally, Milady, our learned friend said, well, there's no flight risk here. There may be a flight risk if the aircraft were at Lanseria, but there's no flight risk if it's outside the country. With respect, that's not correct. There's a flight risk wherever it is, because my client doesn't know where the aircraft is. So if the Guptas want to move speedily from one jurisdiction to another, or if they want to hide the aircraft, they would be able to do so precisely because the tracking device has been switched off. But today, our final submission regarding urgency. Well, let me make 2 final submissions. First, what did the court hear on the prejudice to the respondents of the way in which this case was set down? Lady, what did you hear from our learned friends about their prejudice, even though I addressed that in opening? Not a word, not a peep. Why? Because that's the one thing they don't say in their answering affidavit, that they are prejudiced. They don't say, couldn't find a client, couldn't find someone to give me instructions, couldn't find somewhere to depose the affidavit. They don't say that. They give you the 71-page affidavit with all the annexures. They don't reserve their rights. They don't say they need more time. They were not prejudiced. And that leads me into my final submission. There is a sense of quite breathtaking unreality about this urgency debate. No prejudice to the respondents. They don't claim it. None to them. What does that mean for this court? Well, here we sit. It's now 5:30 on the Friday. It's a special allocation. We all file heads in advance, which doesn't normally happen in the urgent court. The court has read the papers. We've all prepared. We all come before this court, and we argue extended hours. And what our learned friends now say to the court is, no, strike the matter from the roll, in which case my client will re-enroll the matter, and we'll all come back in 3 months' time and have the same debate before another court. With respect, my lady, that is an outcome that simply makes no sense. And it makes no sense where there is no prejudice to the respondents. They're quite right. They didn't waive any rights in relation to urgency. And this court is sitting in effect as an urgent court. But it was specially allocated. Everyone has read the papers. Everyone has prepared. And there is simply no practical benefit to be gained by telling my client to go away, re-enroll the matter, and burden another judge in 3 months' time with exactly the same argument we've just addressed before her ladyship.
Yes, the point made by Mr. Cook about there really is no reputational risk because, EDC has been quite aware of the Guptas and their notoriety. How do you say it? Notoriety. Yes. And despite that, we're prepared to transact with him.
Lady, with respect, I'm indebted to your ladyship for the question. What my learned friend does is he goes to an annexure to our affidavit, a newspaper article, or an online article by Mr. Richard Poplar.
Yes.
And he relies on that. But with respect, that is an article which we put up for an entirely different purpose. And when we said in our founding affidavit that there would be reputational harm to EDC, that was met by a bald denial. There was no attempt to meet the case by saying that can't be right for the following reason. So
the point was made that there will not. There will be reputational harm. You're saying that allegation
my
is not.
says in its founding affidavit,
Yes.
I will suffer reputational harm if I have to continue my commercial relationship with the Guptas in the period going forward. And that is met by a bald denial. What we don't get in the answering affidavit is that can't be right because you knew about the following things before. That is not something that is put up in response to the allegation of reputational harm. And the friends are quite right. In the answering affidavit, they annex a series of articles in the Canadian media.
Yeah.
But the pointed allegation about reputational harm is not one that was made. Let me say this about urgency, and then I promise you I will conclude my submission. The ladyship is quite right. My client relies on reputational harm. My client relies on the risk of damage. But what about the risk of forfeiture? And we heard something from our learned Mr. Cook on that. He poo-pooed it. He said, well, you can always rely on the innocent owner defense. But lady, put yourself in my client's position. It can't receive rent every month from Westall because there is a real risk that that may be the proceeds of unlawful activity, in which case it loses the innocent owner's offence. So what does my client do? Our learned friends say, let us use the aircraft without paying rent. And who knows, in 3 years' time, the English courts will resolve this. But with respect, that is not a risk my client can run. It can't accept the rent from them because the money may be tainted, if I can put it bluntly, and they don't tell us it's not tainted. So what my client says is, I can't accept your money, and I therefore can't let you use the aircraft. And the only solution I can see is to put it in a safe place until all of this is resolved. Without that, my client faces a real risk of not being able to rely on the innocent owner defense. And that is one of the major planks for urgency on which my client relies. Every month you are tendering to pay me the money. I can't take your money, but I also can't let you use the aircraft during that period. And so with respect to ladyship, is right, reputational harm is relied on, but the poker harm is also relied on. And the risk of damage to the aircraft is relied on because the tracker was switched off. And the only explanation you heard from our learned friend is, well, the tracking device was switched off because the Guptas didn't want my client to know where the aircraft was in case they tried to take possession of it. Well, my client indicated it would use legal means to take possession of the aircraft. Didn't have to know where the aircraft was in order to do that. There was no threat that it would use extra.
They didn't want your client to be a nuisance to them.
I'm sorry, Melanie?
They didn't want your client to be a nuisance to them.
Yes, they didn't want.
I think that
our
was
client to be a nuisance to them. So they turned off the tracking device, and lo and behold, it has this collateral benefit, entirely unintended, they say. No one else knows where the aircraft is. But that's not the reason why the tracking device was switched off, they say. That for all of those reasons, it's our respectful submission that the relief sought by my client should be granted. I didn't say in my opening argument, but of course, related to the strikeout, we also asked that the strikeout be dismissed. And Lady, may I have 2 seconds to see if I've missed something, and then I will conclude my speech. Lady, I'm immensely indebted to you and your staff, and I'm sure my learned friends are as well, for sitting so late. It's been a long Friday, but we are immensely indebted to you, and may I express my gratitude to you.
Thank you. You're welcome.
Lady, can we add 10 seconds to that in relation
Would you like to respond?
Just a reference. Our learned friend said he didn't rely on 27.4.
Yeah, 1 second, Mr. Barner. Let me just get a different pen. Right.
Oh, he now says in his oral argument, it's...
Sorry, he said you didn't. They don't rely on
He said they don't
27.4.
rely on 27.4. The carve-out, your ladyship will have regard to page 17, paragraph 27, where there is reliance on 27.
So say that in page 17.
Page 17,
Yeah.
paragraph 27.
Okay. So they do rely on 27.
Indeed. He says, he whispers from the side, he now says in his oral argument, but of course the case is the one made out in the papers, as it pleases the court.
Okay, well, thank you very much for
Well,
the
lady,
very...
sorry,
Oh, sorry, but you want to have...
I also have a...
Very well, you're welcome to.
A final opportunity, and I'll be
Yes,
very
yes,
brief,
yes,
my
yes.
lady. Our learned friend said that there's no mention in answering affidavit about the prejudicial
Prejudice, yes.
time period.
Yes.
That's not correct. If you look at page 445, paragraph 30 of the answering affidavit, the passage reads, to the extent has now been, to the extent that it has been drawn over an extended period, there can be no justification to grant the applicants urgent relief, nor can there be any acceptable reason for subjecting the respondents to such prejudicially truncated time periods. I thus call upon the applicants to provide the following answers. Clearly, we state that the periods were prejudicially truncated.
Thank you.
Thank you.
Yes, thank you very much for the very for the heads of argument and for the very detailed, full argument. Certainly not an easy matter, and I will endeavour to let you have judgment in the next 7 to 10 days. I'm senior judge in motion court next week, so I've got a very full role, but I will endeavour to let you have it for the next 10 days. Okay, judgment is then reserved. The court is adjourned.
Cheers, thanks. Thanks, Alfred. Very much. Might as well check your
All done.